Item number 1.
My lordship, Your lordship, yesterday only I have received this information from the jail authority. As per this oral copy, lordship, it is mentioned that they have organized one medical board, lordship, on 24th of June. After that, they have decided to send the convict person to the MCS or the Dreams Nahalagan within a week, lordship.
As per the direction, it appears that the state has taken treatment of the convict.
Especially for the treatment, lordship, they want
So
for
that is
the
your treatment.
lordship.
State is
Lordship.
taking care of the treatment.
Lordship,
The jail-
that's right,
and
lordship.
if they feel that there is a deficiency in that court,
Lordship.
in that jail, can pray for transfer of the, you see, the convict to the Itanagar, where there is a provision is better. So that provision is there.
Lordship.
It's not a normal bail application. We have to file objection if there is any.
Lordship, yeah, lordship, that's why, lordship, this is received from the Information Procedural Authority, lordship, that they
That
have
is why
already
the
taken
paper
care.
which you have
Lordship,
presented,
they will
probably
taking care of
filed
that,
by
lordship.
way of affidavit.
Lordship. In that way, lordship, this bail application regarding this health, lordship, that it may be, lordship, dispose of, lordship, because, lordship, saying that, lordship, this convict person may be taken care of by the real authority.
Yes, that is why you file
if-
objection.
Yes, lordship, if the merit is concerned, lordship, then.
What?
Lordship.
Lordship is asking you, when there is a convict is in detention pursuant to an order
Lordship.
of the court, trial court's order, in executing that order, then if any bail application filed in the appeal stage, it is the duty of the public prosecutor,
Lordship.
that means representing the state, to file its objection by way of an affidavit.
Lordship.
Such objection should be filed as to why bail cannot be granted to the petitioner in the interim during the appeal period,
Lordship.
right? Now, various reasons you have seen the Honorable Apex Court, whether it is in the any kind of heinous crime, in which circumstances a person can be granted bail. If the convict has completed more than 50% of the term been imposed upon him, and there's a possibility that the hearing of the matter might take time. In those circumstances, they say, but you have to file an objection of why bail cannot be granted.
Lordship.
It is not that it is the duty of the state
Lordship.
to provide all medical facilities to a convict in
Okay.
custody. That is the duty of the state. That is why you are state,
Lordship.
right?
Yes,
You're not a private individual.
no, sir.
So you have to file your application, you have to file your affidavit
No, sir.
explaining the reason why. But in submitting that affidavit, you have to see that some parts of the observations made by the trial court. Right?
Yes,
You
sir.
have to state, these are the reasons, what is the heinous crime, what he was found, and so his bail cannot be granted.
No, sir.
In the interim till
No, sir.
the appeal is pending,
No, sir.
right?
No, sir.
That is the duty of the state. That is why you've been asked to file. That is what brothers also trying to explain to you.
No, sir.
Not that his prayer is for medical facilities.
No, sir.
We are repeating again, duty of the state
No, sir.
to provide medical facilities
Yes.
to all convicts. Right?
No, sir.
He is not an UTP. Even for an UTP, you have to provide it for also convict.
But then also on basis of this information, I'll submit, I'll file my objection, lordship.
It is not that simply you
Yes,
say that bail should not be granted bail, no. You
No,
have to
lordship.
rely on the
Lordship.
trial court judgment,
Yes.
also some little parts of the evidence. Now you have the paper book in your hand,
Lordship.
right?
Yes, sir.
You have to see the evidence. You have to, not in details, but just you have to find out, you have to tell in your affidavit, you have to
Yes.
specify why bail cannot be granted.
This medical board was constituted.
Yes.
24th. Okay. Hard miss. And hard Mr. Clear you. DK there, then counsel for the petition. Applicant. Appellant. Also had Miss L. Hage, additional public prosecutor for the state. The
That could be.
Learned learned additional public prosecutor prosecutor prays for some more time to file objection. However, she had presented a step taken by the state, steps taken by the state for treatment of the convict. As per the document presented by the learned additional PP, the medical board was constituted to examine the health condition of the convict. And after examination of the convict, the board has recommended for surgical specialist urologist consultation of the and to attend at AMCH Dibrugarh or TRIMS, Nahalagan. Stop. Stop. Now, no need to no need to for this correction. In view of the above, list this matter after 2 weeks.
Can it be on 6th of August? 6th of August.
6th of August.
August.
Okay. As prayed for by the Learned Counsel for the petition applicant, list this matter on 6th.
Okay.
In the meantime, the state shall file their affidavit. No objection, state shall file their objection and also comply. And also comply the recommendation made by the medical board for treatment of the convict. Okay.
That's right.
Having you consider FOXO.
As the matter relates to a minor victim under the POCSO Act, live streaming of this proceeding may not be uploaded.
On behalf of Senior Government Advocate S. Tapin, Your Lordship. He has some personal difficulties today, Your Lordship. May kindly take up this matter after vacation. I've taken the consent of the petitioner. Item number 6. Yes.
1-6,
6.
only 6.
Yes.
6 is motion.
No, 6
Or
is
admission.
admission, Your Lordship. After vacation, Your Lordship.
after 4 weeks on any date.
All
To be
right.
fixed by the registry.
Mayor Lordship, I beg to mention item number 4. The leading counsel is due to the health issues, he couldn't turn up today. Therefore, this matter may be adjourned for today.
I'm appearing for respondent.
What is it, Mr. Son? Respondent. You are appearing for all the respondents, Mr. Son?
I don't know, actually, I could not contact my client because he was in the.
No private respondent, Lordship.
Let the matter be fixed on 15 miles.
After, we are not fixing on that because the first 2 weeks we have fixed many cases. So registry will accordingly list it after the vacation.
All right.
Okay. After 4 weeks only it to be fixed by the registry. Yes,
Yeah, my lord. I may be allowed to mention item number 31. 31 and 32. I have taken the consent from the other side.
okay. 32 is 2015 matter, more than 9 years. Are you aware? They were
Yeah, both are
that
connected. Yes.
connected?
Yes.
What is the issue involved?
This is regarding land dispute with regards to issuance of LPC.
Okay. Yes,
Lordship, I beg to mention item number 16.
16.
Yes, Lordship.
Why it is listed today?
Lordship, leading counsel is out of station, so
That is not the case. Why it has been listed today? The matter has been fixed today. Why?
Lordship, it has been fixed by the government advocate.
Ask him to give me the file. Ask him to give me the file.
Lordship, if the matter may be fixed after holidays, after 2 weeks.
You are appearing for whom?
Kamal Saxena by leading counsel.
Office note discloses.
Petitioner.
Office note dated 24/06/2024. That the petitioner is yet to take steps on the respondent number 4 as directed earlier by the court. Such steps on the respondent number 4 shall be taken by the petitioner on or before 28/06/2024. Failing which, the name of the respondent number 4 will be deleted from the cost title.
My lord,
Yes.
I would like to mention item number 5.
Yes,
This matter may be taken up on 19th of July.
we are not fixing any date. It will come in the particular week because
Well, there is some urgency because he was having some personal difficulties back home. He's supposed to take up.
no, Mr. Tara,
My lord,
uh,
my lord can kindly accommodate me in the,
you can have it on the week commencing from 22nd. 2019 is the Friday, so we don't, because thereafter brother Habum will not.
Yeah.
So maybe in the week commencing from 22nd, any day.
that is any date, any date.
Okay. On the prayer of the council for the parties, list in the week commencing from 22/07/22. Any
But-
date on it commencing from 22/07.
Much obliged.
May I, my lord? My lord, I would like to mention item number 25.
Look, I was intending to file amendment application, but your lordship has suggested me to withdraw this application or writ petition. So I may be allowed to withdraw this writ petition with liberty to file a fresh one. I am filing today, my lord.
Okay. Mr. Picha, right?
Yes, my lord.
Full name, huh? Counsel for the petitioner, submitted before the court. There are some inadvertent mistakes in the writ petition. Which could not be incorporated and oblique inserted while filing this writ petition. And as such, praised before this court for withdrawal of this petition with a liberty to file afresh, so that the petitioner can insert all the relevant facts pertaining to the issues involved in this writ petition. Mr. Parme is there?
Yes, my lord. I have informed.
You have informed, Mr.
Yeah.
Parme, any objection in withdrawal? Any objection in
No,
withdrawal? Okay. To which Mr. Al Parme, standing counsel, Power Department of the State, appearing for the respondents, have no objection. Prayer is accordingly allowed. This writ petition stands dismissed on withdrawal. Liberty to the petitioner is granted as prayed for.
My lord, much obliged.
May I, your lordship? Lordship, I beg to mention supplementary hearing, your lordship, item number 28 and 29, your lordship. This matter may be listed after vacation, your lordship.
Twenty-eight, 29,
Yes,
hearing
Lord.
matter.
Yes, your lordship.
This 2015 matter, why, what is the issue involved? Any idea, ma'am?
Yes.
Mr. Nawal?
My lord, the issue is cancellation of registration of this transfer registration, my lord. So matter is almost, my lord, yes.
In the month of August? That will be better.
August, my lord, yes.
That will be better.
My lord, August.
Mr. Panging, what do you have to say? Let it be in the month of August. There will be continuity of the bans and the court. Otherwise, again, we have 15 days on
I have an
the.
interim order.
He's already protected, my lord. So.
Okay, as agreed by the councils for the parties. List. In the week commencing from 5th of August.
My lord.
On a date to be fixed with the registry. In the week commencing from 5th of August.
May I please, Lordship? Lordship, here we are seeking documents from the department, Lordship, to substantiate the honorable court, Lordship. So this matter may be listed after vacation, Lordship, in motion matter.
On the prayer of the council for the petitioner. What's your good name?
K. Tabang, Lordship.
K. Tabang. Matter be listed after answering summer vacation on a date to be fixed by the registry.
W, Lordship.
Item number 2.
Yeah, please, your lordship, here. On the last, after the last hearing, lordship, I personally went to the office of the deputy commissioner, lordship, where we have sought a clarification regard to the circular issued on the last occasion, lordship. So in regard to that, learned deputy commissioner told me that the circular issued still stands, and the subsequent circular which he has issued is just simply extension of date only. So on 25th, there was a sitting between both the parties, but no any fruitful result came on. So therefore, I am pressing the lordship.
You want to praise? Is it required to be praised?
Lordship.
Because how he has exceeded his jurisdiction.
Lordship, kindly,
199, right?
this circular I have annexed.
Hmm.
Typed copies at page 200.
Hmm.
He has issued this circular on 7 June 2024,
Hmm.
uh, stating that to resolve the issue regarding payment works, Your Lordship, kindly take note of it, that payment works between MS Kamakhya Infracom Private Limited and MS Virtual Parang Hydro Project Limited. A meeting is hereby fixed on 20 June 2024 at 10 hours at DC's Conference Hall, DC Office, UPR. Stakeholders who were informed. Thereafter, last paragraph, Your Lordship. Further, the Virtual Parang Hydro Private Limited, Camp Parang, is directed to stop all the construction activities. This is very important. Construction activities till the matter is amicably resolved. When there is a arbitration clause, Your Lordship,
Kindly show
there is
us,
an arbitration agreement.
show us that clause.
Yes. Which annexed at page 60. The relevant part is
Agreement starts at page number
page 55, Your Lordship. Relevant portion is clause. Relevant portion is page 62.
no. The agreement started page, which page?
55,
No.
D series. Yes, Your Lordship.
Okay. Page 55.
Annexure D series. Forming part of contract. Steer. Lordship got it?
Interesting.
Yes. Yes. The first party is the petitioner and the second party is the private, here the respondent. Kamakhya. And mainly
Clause,
Lordship, which is at page 62, clause 14.3. Any dispute or difference in respect of which the employer and the contractor have failed to reach at an amicable settlement pursuant to sub-clause 14.2 within 60 days of the first instance of referral of a dispute by a party to other in writing.
14.2 or 14.3?
14.2 mainly. 14.2 also is relevant. 14.2 says that,
Referring to the arbitration.
yes, it will be referred to the arbitration. Unless an attempt has first been made to settle the same amicably in accordance with sub-clause 14.1. So it is apparent, Your Lordship, prima facie it appears
Contract has been issued to whom? You are only the SPV.
Lordship,
You are only the
Lordship, there
SPV.
is an agreement, Your Lordship,
No,
between
no, the contract was issued to whom? By the government?
that, that agreement is. Lordship, that is at page 27. To me, Your Lordship. There was an agreement, memorandum
This
of.
is the BSS, right?
Lordship, that has been corrected. The name is, which was corrected at page 54, annexure C.
No, BSS, the government has entered into a correct contract with the Messrs BSS.
Yes, Your Lordship.
And you are an SPV of the BSS. Your agreement with the Kamakhya, how come it is Kamakhya Infrastructure Limited?
Lordship, kindly come to page, page 54, Your Lordship.
Huh? The agreement that you are showing before us at this moment
Is,
is,
MS
your agreement is with the Kamakhya Infracron Private Limited.
Lordship.
You are the SPV of Messrs BSS. What was the agreement between you and Kamakhya? How is Kamakhya related here?
So that is the,
You have also given subcontract to Kamakhya or what?
yes, subcontract. Some portion of work,
The SPV can issue subcontract. Was that a condition?
some portion of work.
Is it possible? It is true, as per the agreement between the main contractor, between the government and the authorities and the contractor, to certain extent, subcontract can be given. It is in the terms and conditions. Like here, the petitioner is the SPV of the main contractor, right? So special vehicles provided and everything. Now they are again issuing a subcontract. Whether the subcontractor can again issue
Subcontract to another subcontract.
This has to be in the main agreement.
Some portion of work only.
That has to be in the main agreement between BSS and you.
Yes, yes.
BSS is the main contractor and you have entered into agreement with the Messrs BSS. And you are acting as an SPV of the BSS.
Worship,
You have to first
there was
establish.
a error.
True,
we have
you might
corrected
have
the
given-
name.
But that has to be a clause that being an SPV of the BSS, you can also eligible to issue subcontract for certain portion. That is unless there it is in the clause itself between you and the BSS. How you can enter into an agreement with you and the SPV as an SPV along with a subcontractor? First, you have to show that you have such power to enter into a subcontract. Where is that contract between you and the SPV BSS? You have entered only as an SPV. That is special, what is that clause? 2.23.
Oh, Lordship, the joint secretary power, Your Lordship, and annexure C, kind of,
Page, tell us the page.
page 54.
Page 54, yes.
A letter is written, Your Lordship, whereby with reference to the caption subject, the state government, while letter number so and so, has acknowledged the formation of SPV in terms of clause.
Special purpose vehicle.
Lordship,
Okay. Then,
of the MOA in the name of Virtual Pareng Hydro Project, which is the petitioner, Your Lordship.
right.
In the acknowledgement letter dated so and so, the address of the SPV company was wrongly mentioned, that of the parent company. The address is hereby corrected and may be read as Virtual Pareng Hydro Power Private Limited. Yes, Your Lordship.
Where is your authority to give subcontract as an SPV along with the BSS? Because you have
That is,
an authority under the BSS, right? But where is your authority given by the BSS to give subcontract as an SPV? You may have many disputes,
Lordship,
but that
apparently,
dispute with the relevant party, where is that? The court cannot be a party of an illegal agreement. Show us that you had that power with the BSS. The power has given to you by the Messrs BSS, the main contractor. Okay, you just verify and tell us later. Till then, we'll take other items.
Also, issue with them.
Thirty-three.
Mayor, Your Honor. Your Lordship, this is a contempt application. Herein the respondent, who are the civil revisional petitioner, has filed a civil revision petition. And on dated 22/08/2023, there was a order wherein the order was that the status quo of the land should be maintained by both the parties. Now, the revisional petitioner, who are the respondent here, has started cultivating that land.
They have not complied with.
Order dated 22/08/2020.
What they have done?
Now they have started cultivating that land. After the SCO order was passed by this honorable court in their CRP year.
What's your good name?
R. Raksa.
For the petitioners. The respondents of the contemners as petitioners preferred a civil revision petition being CRP number 43/2023. Which is pending for adjudication. And in the said CRP 43/AP/2023, the present petitioners are the respondents. The court in said, next paragraph, no? Paragraph. The court in said CRP 43/AP/2023 preferred by the respondents as petitioners while issuing notice on 22/08/2023 in the interim stayed the order dated 23/07/2023 passed by the inter-village traditional customary apex court and further directed the parties to decide proceeding to make of the land mentioned in the said order dated 2307-2023 of the Inter-Village Traditional Customary Apex Court. As on said date, I 2208-2023. It is submitted by the petitioners. In spite of such order of status quo as on 2208-2023 being in force relating to the land involved in said CRP oblique 43 oblique AP 2023. The present respondents, I the petitioners of CRP number such and such, are cultivating over the said land and thereby violated the order of the court dated 2208-2023, passed in CRP such and such and such. Hence this contempt petition by the respondents contemners, comma, petitioners of CRP 43 AP 2023. Issue notice returnable by 4 weeks. Petitioners shall take steps for service of notice on the respondents, the 3 respondents, by registered post OTD, providing their correct and proper addresses with requisite postal stamps on or before 28/046/2024. Will you able to take this to service?
Yes.
In addition to the above, the petitioners are also allowed to take steps on the respondents by dusty only personal service that you know, but put it, and thereafter shall file an affidavit. Just file that along with the copy of this list, obtaining necessary acknowledgement from each of the respondents with their signatures and date in presence of one more witness. Thereafter, filing.
Obliged.
Yes, Mr. Tafu.
Yes, Malad, this is a contempt petition for non-compliance of the order passed that is on board dated 21/6/2023. Malad, the direction was that the respondent authorities to pay the admitted amount of rupees 1 crore, Malad, 75 lakhs 4,230 within 3 months from date of receipt of the order. The respondent number 1 received the order on 28/9/2023, and the respondent number 2 received it on 27/9/2023. But till date, no payment has been made, as directed by this honorable.
Which department?
This is Food and Civil Supplies.
Any council representing food? Anyway,
Malad.
we'll give the notice.
Yes. Notice may be issued.
That will issue notice. Heard Mr. Peter, the council appearing for the petition. Matter relates to non-compliance of the order dated 21/06/2023, passed by the court in WPC number 640/2018. We'll give the party's name, no? Dopam Dolo Women Welfare Development Society. Versus State of Arunachal Pradesh. And 2 others. Whereby the court directed the Chief Secretary of the State, respondent number 1, the Commissioner, Public Secretary, Food and Civil Supplies, Government of Arunachal Pradesh, respondent number 2, and the Director, Food and Civil Supplies, Government of Arunachal Pradesh, respondent number 3, diary, to pay admitted amount of rupees 1,75,04/230 to the petitioner of said WPC number such and such within 3 months from the date of receipt of the certified copy of the said order. The petitioner on receipt of the certified copy of the said order of the court dated such and such noted above dated 21/06/2023 noted above submitted the same before the Commissioner Secretary Food and Civil Supplies on 28/09/2023, obtaining necessary acknowledgement from the said authority. Similarly, the petitioner has also submitted a certified copy of the said order dated 06/2023 noted above before the Director of Food and Civil Supplies, which was received by the said authority on 27/09/2023. To that extent, petitioner have placed the copies of relevant receipts and the certified copy of the order dated 21/06/2023 passed in WPC number
640.
640/2018 as an access to entry respectively. In spite of being more than 3 months since September 27 and 28th of September 2023, since the respondents have not complied with the order dated 21/06/2023, passed in WPC number such and such, releasing the said amount of rupees such and such to the petitioner. This contempt petition has been filed against the present respondents. Issue notice or returnable by 4 weeks. Petitioner shall take steps for service of notice on the respondent number 1 and 2 by registered postal date providing such and such on or before 28. I will not say.
No, no.
You can correct, you can do it.
Here in the case,
Yes, Mr. Patil.
as per the departmental inquiry, disciplinary inquiry, the report was submitted on 30/3/2023. On the basis of that inquiry report, the disciplinary authority has dismissed my charges. But as per the Rule 23 of Central Civil Service Conduct and Appeal Rule, that I should go for the appeal. Accordingly, appeal before His Excellency that is in
Mr. Nawab,
169 page, Annexure 7, that is my appeal.
your appeal
Yes, I have made an appeal.
is pending still for consideration.
It is still not yet disposed of. And because of that, now 206 days have passed after submitting the appeal. The appeal was received on 30/11/2023. And unless this appeal is disposed, I cannot come to the writ court because there is one.
Okay, we'll direct to dispose it on or before 31st of July. Oh, it is pending before the governor.
Governor, that is the main problem.
I can do one thing at best. After reopening of the court, this letter will be listed again on sometimes in the week commencing from 22nd.
In the
You
meantime,
obtain the information from the secretary of the
Governor, my
Governor.
lord. Yes, my
the stage of this,
lord, I'll do that.
right?
Right, my lord.
And then only it will be possible.
Right.
At this moment, we don't like to issue notice to His Excellency in this case, sometimes because it may not be brought to notice His Lordship. So His Excellency may not be aware of all these provisions. It is the normally what happens, it is the secretary has to work more on it. Get the information from the secretary
My lord, yes.
to the governor.
So let it come after vacation, my lord.
Yes, we are giving you a date. It will be better sometimes in the 25th of July,
My lord, 25th of July.
or in that case,
Let
okay.
it come on 29, my lord. 29 July. Ajay.
No,
Right?
Mr. Patil.
29 July.
Okay. The petitioner was serving, heard Mr. Empati from the senior counsel, assisted by Mr. Parme for the petitioner. Also heard Mr. Arich Nabam, learned additional advocate general of the state, appearing for the respondent numbers 1 to 4. The petitioner was serving as a joint commissioner in the Department of Tax and Excise, Government of Arunachal Pradesh. In a disciplinary proceeding under the CCS of CC Rules 1965, by an order dated 2010-2017, in disciplinary proceeding under the CCS initiated against him under the CCS rules by memorandum of charge dated 2010-2017. He was dismissed from service on 09/11/2023. Where is that order of dismissal?
No, dismissal order. That is in,
Issued by the Chief Secretary.
yeah, there's Alexa 6,
Page 166.
page 166.
Right. Against his dismissal order dated 09/11/2023, the petitioner, as per Rule 23 of the CCA rules, first you will write Central Civil Service, within bracket, class, control, and appeal bracket code rules 1965. Then in the next case, you will write CCS, within bracket, CCA rules. Prefer an appeal with His Excellency the Government of Arunachal Pradesh, which was duly received on 30/11/2023, which is yet to be disposed of. Hence this writ petition. List on 30/07/2024, enabling Mr. Arich Nabam, learned additional advocate general, to apprise the court about the status of said pending appeal of the petition filed on 30/11/2023, Annexure 7 to this writ petition. Petitioner shall serve 2 extra copies to Mr. Navam Ladit within 2 days from today. Copy of this writ petition along with the annexure for his necessary use. Yes, Mr. Saikia.
May I please, my lord? My lord, for the purpose of, my lord, land acquisition, my lord, in the state of Arunachal Pradesh, for the infrastructure development, my lord, the government of Arunachal Pradesh has adopted the, my lord, Fair Act, my lord, in the year, my lord, 2014 itself, my lord. And for the construction, my lord, not exactly construction, my lord, widening of the, my lord, existing road from, my lord, Tiding to, my lord, Arwa, it's called, my lord. My lord, at the 3 points of time, my lord, the land has been acquired, my lord, by different acquisition, my lord. In one category, my lord, they had acquired under the, my lord, the provisions of the, for the same stress of land, my lord, they acquired under the provisions of the 2013 Act, my lord. And given the, all the, my lord, components of the 2013 Act, my lord. And in one parcel, my lord, they have acquired under the Act, my lord, under section 10, but given the, all the provisions of the 2013 Act, my lord. And the rates of the land were given, my lord, 250 per square meter, my lord. In my case, my lord, my land was acquired under the Jumland Act, my lord. My lord, before the notification, my lord, issued for acquisition under Jumland Act, my lord, the award has been passed, my lord. After award has been passed, the land acquisition notification was issued, my lord. Then we have objected to that, my lord.
Award was part under which provisions?
Under the, my lord, Jumland Act. Lordship will find
Hmm.
the award at page, my lord, to 57, my lord. Sorry, my lord, 75, my lord. This is the a letter, my lord, by way of notification by the DC to the, my lord, Director Land Management, my lord. And the type copy you will find at page lord 76, my lord. At 77, my lord, the cost of the 77, my type copy, my lord, serial number 1, my lord. May I read this entire, my lord, letter, my lord?
Just a minute. How they have calculated 1.68 lakhs?
My lord, that was, my lord, in the approval letter, my lord, we have found that, my lord. Approval letter also will find at page, my lord, 84, my lord.
Yes.
Here, my lord, type copy is at page 83, my lord. On the basis of that letter, my lord, the government has approved the rate, my lord, approved the award, my lord. Page 83 is the, my lord, type copy, may I read, my lord?
Yes.
Approval for LA estimate against kilometer 45 to 50 and 0 to 54, Havliang, Changwani and between Changwanti, Walam, Namti and Anjao district. With reference to your letter number such and such dated March 2021, this office notification number such and such dated 11/5/2021 on the subject cited above, I am directed to convey the approval for the LA estimate against the acquisition of the land for construction of defense road for widening improvement of existing road to NHDL specification area measuring such and such under highway Walong Circle Anjao district, my lord. And lords, you will find the extract sheet, my lord, of the award, my lord. And the rate was at column, my lord, 1, 2, 3, 4, 5, 6, column 6, my lord. My lord,
Column 6.
6, my lord, from right to left side, my lord, the rate of land, my lord, per square meter, my lord.
No, market value of land has been assessed.
Only rupees 11 was given, my lord.
1,18,800.
Yes, my lord. But my lord, rate is, my lord, land rate is, my lord, only 11 rupees, my lord.
Where from you are reading?
Rate of the land is given only.
One is name of landowners, then Chinese,
my lord.
length of land, width of land, area of land, rate of land per square meter. Okay.
This is being we are agree of, my lord. And my lord, this approval was made, my lord, on the basis of a, my lord, award passed by the, my lord, the deputy commissioner prior to the minor land acquisition notification minor. Minor land acquisition notification will see at page 80 minor.
No, this estimate was forwarded by whom?
By the DC minor, deputy commissioner Anjao minor,
No, there will be a letter from the deputy commissioner to the government
government
for
minor.
approval.
Yes, ma'am.
There has to be an indication
Ma'am.
that it was, no, nowadays what is happening, as the requiring departments are not depositing the amount
No, no.
and the
ma'am.
land is required urgently, days to process,
Yes.
days to process, and days to get the money deposited in the account of the deputy commissioner so
In
that
advance,
they can disburse the amount immediately when the land is taken over.
Yes, ma'am.
So, without issuing any such notice,
Yes, ma'am.
possible.
Possibly.
Though we will not say it is not in terms of the relevant rules, but most of the acquisition cases, because of the failure on the part of the acquiring department. So that is what the DC has done it. Throughout the India, they are doing the same thing, whether it is for the national highway or for other roads acquisition process. But notification has come when?
My lord, only on in the, my lord, 27 April 2021, my lord. After
Where is that notification?
Lords, you will find at page 80, my lord.
The government approval was given on 11th May
My lord.
21 or when? The government approval came on,
My lord.
government approval was of 5th of July.
5th of July, my lord.
Okay, where is the notification?
Notification is at page, my lord, 80, 27, my lord,
80.
4 to 80, yes, my lord, 80, my lord.
This is of 27 April 2020.
Yes, 2021, my lord. At page 81, my lord.
Huh.
May 11th May 2021 issued on my lord.
Page 80, last paragraph. What you have done? Page 80, last paragraph, before the serial.
Therefore, any person who has any objection to the acquisition of the said land for the purpose of we file objection in writing to the deputy commissioner, however, within 30 days from the date of publication of the notification, clearly mentioning the reasons for such objection. The deputy commissioner, however, in her capacity shall dispose of the same after giving reasonable opportunity of hearing the claims and objection of the owner. No claims and orders shall be entertained after expiry of a stipulated period of time. My lord, we have before that also, before the notification was issued, my lord, a public meeting was, my lord, conducted.
No, that is fine. After this order was passed, this award was passed,
My lord,
notification was issued.
yes,
what
my
you have
lord,
done.
representation lordship will find at page, my lord, 89, my lord.
Where was received by the office?
Office on 20, receipt was given here, my lord. 21/9/2021, my lord. No, in the bottom, my lord, 7/6/2021, my lord.
Now, what was their claim there? You have claimed.
We have claimed that, my lord, since we have objected to, my lord, the rate, my lord, given, my lord, for the land, my lord, at the rate of rupees 11 per square meter, my lord. And we have also said that, my lord, our land should be acquired under the new act, my lord.
Yes, Mr. Ratan, you are representing land management?
No, my lord, I'll be representing.
Deputy Commissioner.
One, yes, my lord.
You are land management, yes.
I've got two, ma'am.
Is there any standing counsel for NHIDCL?
NHIDCL, No, my lord, on case basis, my lord, they appoint.
And we will take it.
Heard Mr. Arsaker, counsel appearing for the petitioners. Also heard Mr. Learned counsel for the restaurant number one, sorry, okay, Mr. Richard. Learned additional advocate general of the state for the restaurant number one. Mr. Kamduk. Learned standing counsel. Land management for the restaurant number two. By notification dated 27/04/2020, but issued on 11/05/2021. The Commissioner Land Management Department, Government of Arunachal Pradesh. Notification, you make the number also. LM-212/ACQ/2021. Acquired the land of the petitioners under section 10 of Balipara-Tirap-Sodia Frontier Tract Zoom Land Regulation 1947. In the for widening of the this is
Highway,
no, place is village, but it is for the national highway, defense land or something.
Defense road, my lord.
For the defense load land, or this is there is a particular name.
My name is it, my lord, in
And
under the
it's
notification,
DL, I
my
think
lord.
so.
Second paragraph, my lord.
And is this specification defense road?
Okay. For existing, for an widening and improvement of an existing road to National Highway Defense Land. Specification of road in respect of Hawiliang dash Changwinti, CHANGWINTI, between kilometer 45.05 to kilometer 50.820. And Changwinti dash Walong dash Namti, you will get it, page number 80. Just mark it. Huh? From kilometer 00.00 to kilometer 54.450. For which the joint survey and assessment was to be carried out with effect from 17/7/2021 to 06/08/2021. The petitioners are aggrieved as the land value for their land acquired for widening of the improvement of the existing road to NHDL as noted above has been assessed only at ₹11 per square meter instead of assessing the compensation and paying the land value for the required land for the said road under the provisions of the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act 2013 has been followed in other similar cases while widening or improvement or constructing
On the same stretch of road, my lord.
road, particularly in the same stretch of road in other parts. In that regard, the petitioner submitted their representation on 03/06/2021 before the Commissioner Land Management, Government of Arunachal Pradesh, which has not yet been considered, Issue rule returnable by 8 weeks. As such and such receive no formal notice. Petitioner shall serve requisite extra copies of such and such and the annexes to Mr. such and such on or before 28/6. Petitioner shall take steps for service of notice on the response number 3 by registered post OTD, providing its correct and proper address on or before 28/6. Will you take justice service on the response number? In addition to the above, petitioners are also allowed to take steps on the response number 3 by justice service, just till the persons are same order. Okay. Pendency of this writ petition shall not be a bar for the respondent authorities, particularly the land acquisition collector, deputy commissioner, as well as the secretary land management department, to consider the prayer of the petitioners regarding the assessment of their land value acquired for widening or improvement of the said road under the provisions of the LAR Act 2013.
I have a humble my lord prayer for my
As
lord.
for the assessment.
My lord, I have also a humble prayer for the interim, my lord. My lord, as because in terms of the award, my lord, they have deposited the compensation amount, my lord. That may not be, my lord, released to.
Why? You object, you'll get the money at least. For that, you don't have to. Which page?
Lordship,
Where is that contract between you and BSS?
no, that is not the issue, Lordship.
Okay, have you
Here-
stated so?
Yes, as per MOU, Lordship, here the petitioner is not contractor, Your Lordship.
Yes.
He's a license holder. Your Lordship.
That's right. It's an SPV only.
Yes,
Then,
it's license holder and has invested its own money, Your Lordship, for the development of the project.
see, basically, you and that Mrs. Kamaikya, you have an agreement.
Lordship,
You have entered an agreement with Mrs. Kamaikya.
yes,
For that purpose, in the main agreement between you and BSS,
Uh,
is there any mention?
Lordship, me and the power department.
Huh?
Kindly come to the, at page 28 of the agreement, MOU. Lordship, wherein it's including without limitation to the special purpose vehicle to be created for execution of powering hydroelectric project 14.5 megawatt is the second part. Lordship. And then clause 2, Your Lordship. Clause 2, wherein it states, Gamena PP has earmarked certain projects for allocation to private developers for the development of hydropower projects in the state, which will generate economic activity in the state leading to its growth. Your Lordship. Page number 28. And will also serve as an engine to achieve the objective of the promoting all-round development in the state and the country. And also, Your Lordship, at 2.23. And at page 38 of the same MOU,
Yes.
clause 2.23. The company shall be permitted to create a special purpose vehicle SPV for implementation of the said project under this agreement. The state government agrees to transfer, issue all such permission approvals relating to the project as may be required in the name of SPV. Therefore, Your Lordship, by virtue of that MOU, here the petitioner is the not contractor, Your Lordship, he is a licensor, invests his own money for the development of the project and has issued contracts for construction, supply, execution, etc.
See,
To several
Mr.
constructors,
Singh,
Lordship.
in the project of BSS that has an agreement with the government,
Yes,
right?
yes,
You are a part where it has been specified by the BSS in
Yes.
this agreement between you and the BSS,
yes,
right?
yes.
Now, please come to your contract agreement at page 59 between you and Infracon.
Yes. 59.
From there, you kindly show us that you have engaged Kamaikya Infracon for any such project where BSS is involved.
In regard to that, sir, BSS is, there is a contract that letter, that was already corrected, Your Lordship, by virtue of
We
one
understood.
letter.
That's, there is,
That-
see, Virtual Pareng Hydropower Limited, we understood.
Hmm.
Virtual Pareng Hydropower Private Limited has the authority as per the agreement between the state and the BSS. Right?
Hmm.
So now, as per that, you have to involve or you are involving Kamaikya Infracon
Yes.
in your other project or for the project where the BSS is involved. Because you got the power only through BSS. You and the government doesn't have any such agreement. There is no agreement between you and the government. Agreement is between you and the government and the BSS. And the BSS has between agreements between you, which the government have accepted.
Yes.
Now, the any kind of agreement that you are having with the Kamaikya Infracon Private Limited should be related to the projects where the BSS is involved. Kindly show us from this contract agreement that you have empowered or have entered into this agreement relating to BSS.
Lordship, this petitioner and BSS is the same, Your Lordship.
Good.
By virtue of the later, Your Lordship, we have
Hmm.
corrected. And actually, see, Your Lordship,
Okay. Okay.
with, I have read also, Lordship, may I read, Your Lordship? Relevant part. With reference to the caption subject, the state government by letter number so-and-so dated has acknowledged the formation of SPV in terms of clause 2.23 of MA in the name of Virtual Pareng Hydropower Private Limited, incorporated by MSBSS Project Private Limited for implementation of Pareng Hydroelectric Project, 14.5 megawatt. In the acknowledgement, later dated 15/11/12, the address of the SPV company was wrongly mentioned, that of the parent company. The address is hereby corrected and may be read as Virtual Pareng Hydropower Project, Private Limited. This. Therefore, the present here, the petitioner is
Okay.
Virtual Pareng. The said letter is also being issued by the Joint Secretary Power with the BSS project privately. And so far as the clauses which I have already mentioned here. So these are the developmental project, Your Lordship.
Leka. Heard Mr. A.K. Singh, while counsel appearing for the petitioner.
My lord, may I submit something, my lord? The lord says, my lord, this MU signed by the government of Arunachal Pradesh and the BSS. There is a specific clause where it says, my lord, they cannot sublease, my lord. By taking your lordship to, my lord.
No, but there is a clause for BPL, no?
I'm sorry, my lord.
That is, there is a specific clause for the issuance of this, this is a page, just a minute.
My lord, I'm not on that point, my lord, SPBs, my lord. Yes, my lord, they can. But SPBC is, as per this definition, is a, within the company is some organization, my lord, which will carry out the project, my lord. So within the company.
At this moment, we will not say to that. We don't know how, see, the letter of the respondent number 3.
Respondent 3, my lord, if your lordship see the complaint lodged by this
And how
private
come,
respondent, if your lordship
that is
sees, my lord.
also very interesting that they are constructing hydroelectrical projects at page 192.
Yes, my lord.
How come they are doing the project under the government,
My lord,
hydroelectrical project? They are
That-
doing hydroelectrical projects in various civil works. That's been, the government should have. If
that
their
part, my
government
lord,
is
they have
aware-
to take instruction from the power
That's
department.
right, that is the reason.
Yes, my lord. Otherwise,
Mr.
my lord, the allegation made by the private respondent.
That is a different issue, but thing is this, we don't know how come this particular organization is or a, this is,
The power department, they allowed to
you will appear,
sublease another contractor.
you
My
will
lord.
appear only for respondent number 2.
Yeah, only for the DC, my lord. Power
Who is for
department.
the power department? Come do, permit,
Permit,
uh,
yeah, my lord.
and permit. Council appearing for the power department, standing council power department of state, respondent number 1. And Mr. H. Navam, Additional Advocate General for the respondent number 2. The respondent number 3, Kamakya Infracon Private Limited, within bracket KIPL in short. On 21/05/2024, submitted claim before the Deputy Commissioner Papumpara District UPR respondent number 2, stating that it has been working at Pareng Hydroelectrical Project since October 2010, 2021, based on the letter of award LRA capital in favor of
Respondent number
issued
3.
in its favor by the Parsuel Pareng Hydro Power Private Limited, within bracket VPHPL, in short, the petitioner, bracket of in short, petitioner, by its letter dated 30/09/2021. And that the petitioner has failed to comply with his contractual obligations ever since the publication of tender documents for Pareng Hydroelectrical Project in the year 2017.
Lordship, this is not a tender, your lordship.
This is not tendering.
No, not tender. This is
is
a
complaint.
memorandum of MOU, your lordship. And it is not like that government of Arunachal Pradesh is providing money. Now. It's my own money, I think.
This is your letter. This is the letter of the respondent number 3. This is a complaint.
Yes.
As such, the respondent number 3, by the said letter dated 21/05/2024, requested the respondent number 2 to intervene in the matter and to instruct the petitioner UPHPL to settle its all pending issues by releasing their pending payments and to provide all the prerequisite to start the works at site, etc. Annexer M to this writ petition. On the basis of the said complaint of the respondent number 3, the Deputy Commissioner, Papumpare District UPA, by the circular number PP/ZUD-0957/2024, dated 07/06/2024, directed the project manager of the petitioner, the project manager of the respondent number 3, and other authorities mentioned in the said order, mentioned in the said circular, further directing the petitioner to stop all the construction activities till the matter between the petitioner and the respondent number 3 is amicably resolved. It is stated by the petitioner that an agreement, a contract agreement was signed between the, it is stated, a contract agreement was signed between the petitioner and the respondent number 3 on 29/10/2022. Wherein at clause 14.2 and 14, both the petitioner and respondent number 3 agreed that if there is any dispute between them as contractor and the employer, such a dispute shall be referred to arbitrator. That will be settled as per the provisions of rules of arbitration of the Indian Council Arbitration. And the Indian Arbitration and Conciliation Act 1996, which are binding on them. It is stated by the petitioner, in spite of having such arbitration clause in the agreement between the petitioner and the respondent number 3, the Deputy Commissioner, Papumpare UPA, respondent number 3, exceeded the jurisdiction in directing the petitioner to stop all the construction activities till the matters are amicably resolved, while issuing the incumbent circular dated 07/06/2024. Annexer and to this petition. I got the agreement con sir. Agreement con Annexer D series really. Issue notice returnable by 5 weeks. The maintainability of this petition shall be considered at the time of its admission stage. Next. The petitioner shall serve requisite extra copy to Mr. Parme, representing as for number 1, and Mr. Nabam, representing as for number 2, by tomorrow obtaining necessary acknowledgement from name in that regard. Petitioner shall also take steps on the rest for number 3 by registered post with AD, providing its correct and such by tomorrow. Till the next date of listing, the observation of the Deputy Commissioner, Papumpare District, UPA, as for number 2, issued in its circular number PP/JUD -0957/2024 dated 07/06/2024 pertaining to the stoppage of all construction activities by the petitioner Virtual Parang Hydro Private Limited till the dispute between it and the respondent number 3 is amicably resolved, shall remain suspended.
Mala, sorry for interruption, Mala. That observation may not be made because there is subsequent order he has issued, Mala. Wherein, Mala, there is no such restriction.
That I have produced last occasion also.
No, do one thing. Issued in that letter is there, no? That letter. Subsequent issues is not there, only with regard to that circular dated.
Because that has been superseded by subsequent
No.
circular, Mala. Yes, yes.
It's not superseded. This is an extension of date only.
Which we are not, Mr. Nabam. It will be automatically meaningless. So basically what we are doing only specified in the circular 7. If by subsequent notification or subsequent circular it is there, it will have anyway no effect. That's why we are saying the mentality is there. You can always place it on the next date. Because your circular of 17 is a part of our document. You have placed it on the next date. We have seen to that.
Because this was not annexed in that petition.
Yes, it is
Subsequently,
before
that
us.
petition.
It is before us.
It
But
was
it is
passed
like-
in the evening.
It
It
is
was
there
passed in the evening
only
after filing the
in this circular dated such and such shall remain suspended. That's all.
Pretty much.
Made to you. My lord,
Mr. Tagum,
yes, sir.
yesterday we have passed an order in your absence.
My
Your
lord,
junior was there.
my lord,
Don't appoint anybody who doesn't fulfill the criteria of the NCM
my lord, my lord.
because it's very specific. There
My
is
lord.
the observation, there is and.
Yes, sir.
And is the PhD from a recognized university within own campus, not from outside campus. Staying at place A, having PhD degree from a place C far off,
My lord,
and that also outside campus will not do. That is
My lord.
very specific clause.
my lord,
So don't appoint anybody.
my lord, my lord,
If
there's a-
somebody-
even the rule also permit that part, my lord, that is there.
So basically, if the candidate selected is not having that kind of PhD degree from the off campus will not do. It should be inside.
The
campus.
appointment has already been done, but they are as per the result.
Whatever. It will be clarification for you. You cannot do that. You knowing fully well, you cannot violate the NCM. Yes, Mr. Pangi.
My lord knows, my lord, the state of Arunachal Pradesh, except for a few departments like the Home Police Department, we don't have our own conduct rules. So, my lord, we have adopted the CCA rules. Now, under the CCS,
This is everywhere. Nam Mizoram in Nagaland, same thing. Yes.
Rule 10(6) provides, my lord, a suspension will have to be reviewed before a period of 90 days. 7 says, if it is not reviewed, it will not be valid. Now, my lord, will see the impugn order,
Page.
32. Because I am praying for notice only at this stage. Whereas, yes, my lord got it. Whereas such and such was arrested in connection with illegal appointment of such and such in a case has been registered under such and such. Whereas the undersigned in exercise of powers conferred by sub-rule 1, it should have been 2, my lord. The date of detention in case of detention in trial for a period exceeding 48 hours of Rule 10 of CCA 65. Hereby place the said such and such under suspension with effect from 9/2/2024. Next slide. It is further ordered that during the period of trial, this order shall remain in force. Evidently, my lord, illegal and my lord, also in violation of Ajay Kumar Choudhury. I'm praying for notice at this stage.
Mr. Tamuk, why
My lord,
The judgment of Ajay Chakraborty passed when?
2015, my lord.
By this
Evidently, my
time,
lord, during-
everybody, all departments are aware.
my lord, Ajay Kumar Chaudhary, my lord, there said,
It has to be reviewed within
my
90
lord,
days.
that is there, my lord, certain
It's
certain
a
aspect
report-
also to
listen,
be
listen,
considered.
listen, listen. There is a reported judgment of Justice Arup Kumar Goswami in the GLT. That matter relates to IIT. That matter, His Lordship has dealt with these provisions very well, along with the Ajay Chakraborty.
My lord,
The issues was raised therein by the IIT. And then, as His Lordship passed the order in favor of the incumbent, and then the IIT, being mighty force, went to Apex Court. Apex Court has upheld the decision of His Lordship Justice Goswami. It's a reported judgment in the GLT. Now, thing is this, whether is person under suspension, whether you serve a memorandum of charge within 90 days.
my lord.
Giving memorandum of charge within 90 days is less like the default bail, right? And that is, you know very well. But the power of review
Yes.
within 90 days to keep
Exactly.
somebody under suspension, you cannot continue.
Yes.
My lord.
You have to review, even if you have given any memorandum of charge within 90 days. Once you give the memorandum of charge of the 90 days, that means the proceeding will initiate it, you have to complete. But you cannot keep a person under suspension. The reason is very clear. Of course, those rules are not here before us. And there is a manual or some Assam Service Disciplinary Appeal rules.
Yes,
Those
my lord,
rules are-
Assam is also there, separate rule they have.
Except that haven't followed the CCA rule only, but there
Yes.
is a manual.
In the line of,
In that
CCS.
provision, there is a manual there, how the office, the departments will follow. There are two parts. One is at page 50, or the provisions is 52 or something. In those, it has been specifically mentioned. That's a manual for the department to follow with the suspension matters. That is in the Assam Service and Disciplinary Appeal rules. But that has also been taken from the CCS rule.
My lord.
Now here is, where is this particular, see, you cannot keep a person under suspension
That is-
for the entire period of trial.
That is right, my lord. That is now at this stage, my lord, whether department proceedings are going on now, but that we'll have to take, we'll have to see.
See, whatever you do, but
Now,
who is in this order?
my lord, that is why,
He is not a, somebody,
my lord, that is
he
why.
is not the Borobabu or UDA
My lord,
who is issuing,
my lord,
who has signed this, who has issued this, the head of the department.
my lord,
He
that's
cannot
why
act like this.
we require to see the record, my lord. And
Mr. Tagum.
that's the case.
Before issuing this order, it is the duty of the commissioner of the concerned department to, while issuing, be very careful. Clearly, this is in violation of the order of the Honorable Apex Court. How you can state an order that continuation of the trial,
There never may be a trial also.
My lord,
Mr.
This
Tagore,
order is, my lord, incorrect in many ways.
see, you are legally educated. Your duty is that you will inform your department. Don't support your being the standing counsel of a particular department doesn't mean that you are not a court officer. You don't have to comply with everything what they have said.
my lord, that is right.
Since last week you are saying, don't allow them to sit over your head. You should sit over their head. That's not the case. A simple sentence is enough from this observation. Here we have that, we have seen. So this can be stayed now itself. But since it's more than, it was in 19 February, we are in the end of June. We are not passing any order. Right? It's more than 4 months. But things you are supposed to review.
My lord, my lord,
Mr.
my lord,
Tagum,
my lord, sin, Ajay Kumar
this is,
Chaudhary case
this is
my lord.
something, this is something absolutely, the word we call dadagiri. It's just like this. You cannot do that. You cannot. See, basically from a higher officer, what do you expect? That he should be reasonable enough. Higher officials always should be reasonable enough and be comply with the rules. How he can pass an order that during the period of trial, that cannot be, Mr. Tagore. Heard Mr. Pangik, Land Counsel appearing for the petitioner, and Mr. Titagum. It's Standing Counsel Education Department for all the official respondents,
All the
number 1 to 4. Petitioner was arrested in connection with a Vigilance Department police station case. Number 03/2023 under section 120 within bracket capital B /42040946847 IPC related with section 13 within bracket 2 of the Prevention of Corruption Act 1988. And was kept in custody for more than 48 hours. Following the provisions of CCS within bracket CCA rules 1965, by order dated 19/02/2024, the petitioner was suspended from service with effect from the date of his arrest, with effect from 09/02/2024, i.e. the date of his arrest. In the said order, dated 19/02/2024, issued by the Commissioner within bracket Education, Government of Arunachal Pradesh, respondent number 1, categorically observed that the petitioner shall be under suspension during the period of trial of the case. Full stop. Since the said order of suspension issued by the Commissioner Education dated 19/02/2024 indicates only about the police case, vigilance police case, it can be presumed that the Commissioner meant the trial of the said criminal case. The petitioner is aggrieved as the respondent authorities in violation of the orders, in violation of the provisions of the CCA or in bracket CCS rules 1965, till date did not review his suspension order in spite of more than 90 days of his suspension, comma, as required under the said 1965 rules. Issue notice returnable by 4 weeks. As Mr. Tagum such and such accepted notice on behalf of all the official respondent number such and such. No formal notice, steps by tomorrow, serving copies such and such. Pendency of this petition shall not be a bar for the respondent authorities in the Education Department of the state to consider, to review the suspension of the petitioner as required under the CCA within bracket CCS bracket close rules 1965, if not already done within first 90 days and thereafter from with effect from 09/02/2024.
But if that liberty is granted, they may take it as a handle to.
No.
They're gonna do it now.
First, if not done, finish.
That is
If they
right.
have done, they will continue to do it every 90
Yes,
days.
I'm sorry.
If not, they have done, because otherwise,
Yes.
that is, if they have done after 90 days, automatically you will be reinstated in service.
Yes.
That's the law.
Yes.
Rest up
38
to 40, same suspension order, same out of the FIR, same.
38 to 40, same order.
38,
39 and 40.
39, 40, same order.
Same.
Same vigilance PS case.
Same. Exact.
38, 39,
And 40.
Okay.
Same.
Clearly to clearly, if shall not be responsible, sir, if they have done the review within the first 90 days from 9 to February, sir, and thereafter.
Yes, and that may be correct. Okay.
They are bound to do.
Yes, but otherwise, my lord, they may think that
No.
after 90 days, they
If they
might
have
not
done
have
it after
given them the
90
liberty.
days, finish.
My lord, of that.
37 or 37, 38, 39, all the same. Just a minute, I'll put this. 37, 38, 39. At order again, money dekhaba. Bishop Praklita. We Khali Likiva, 52 Likiva, 38 Likiva, less this matter argument WBC 250, 39 to Likiva, 42 Likiva.
Please, Your Lordship. Prisoner has been declared as L1 my lord. Even after declaration L1 my lord, they have not finalized the tender my lord. For seeking finalization of tender my lord, I have preferred this petition my lord.
Who is appearing?
No, my lord, what happened, my lord, after filing of it petition yesterday, my lord, yesterday evening, my lord, they have sent a mail to the petitioner, my lord, which petitioner has checked up to afternoon only, my lord, he has sent, my lord, where the authority has asked for retender of subject matter, my lord.
You file an additional affidavit.
My lord, you will see at page 156, my lord, 156, my lord. While they ask to extend our bid validity, my lord, it has been observed in the letter, my lord, second paragraph number 2, my lord. That the case was referred for obtaining financial concurrence, my lord. There was no whisper of, my lord, irregularity in all, my lord.
When the financial bids were open?
The financial bids were open on 23rd of March 24, my lord. It is there in paragraph number 24 itself, my lord. After filing the petition, they will.
Where is the NIT?
My lord, NIT, you also will find it, my lord, page 14, my lord. Sorry, my lord. It starts from page 13.
Who issued it?
Responding number 2, my lord. Sorry, my responding number 3, my lord. Lord, you will find page 40, my lord. Responding number 3, my chief engineer project Brahma will be the accepting officer, my lord. It is mentioned in page 40, my lord. Paragraph clause 8, my lord.
Now, the letter that was issued to you on 16/5/2024.
My lord.
Page 156.
My lord.
Was issued by one superintendent engineer.
On behalf of chief engineer, my lord.
Where is that?
My lord, at the bottom, my lord. 154, on behalf of chief engineer, it was issued, my lord,
For chief engineer.
for chief engineer. Now, my lord, from page 40, refers, my lord, chief engineer project will be the accepting officer only, my lord, page 40. Page 40, clause 8, my lord.
Yes.
8, my lord, the chief engineer project Brahma, care of 99 APO, will be the accepting officer here, in after referred to as for all such purpose in this, contract, my lord.
Whether letter of acceptance was issued to you?
No, my lord, it was not issued, my lord. I was declared L1 when we were asked to extend our validity, which we have extended, my lord, up to 20th of July, my lord. Now, my lord, they are moving in a very hurried manner to retender, it appears, my lord.
Yes, Mr. Katuk.
Well, there must be some reason why, well, the L1, well, it is settled positions that all L1 should be given or awarded.
That is not the issue. The reason for retendering.
Well, reason for the retendering is,
There has to
though
be the-
L1 has been, well, the L1 category has been given,
See,
but it is not always.
As you know,
Well,
for a particular tender, the parties submit their particular amount,
Right.
right? So if such amounts are discloses after the opening of the tender of the financial bids of the responsive tenderers, and if you decides to cancel the decided tender process, go for retendering, what will happen? The rates will be known to all. That is why the Apex Pro has clearly written the law that you must have a valid reason for retendering. Right? It is true that in all cases, the L1 need not be
Right.
allowed.
yes.
There is also reason. If the rates are 5% above, 5% below, if it is below the rate, various clauses are there. So, but for retendering, there has to be reasons once the financial bids are open.
Correct.
Here is a case, you have opened the financial bids and the petition has been considered as L1.
L1.
Now from this letter, it is what we can see is there is a process of retendering, right? And then retendering, as on, there is no reasons before us at this moment why
Well,
for the retendering.
yes.
Does. Maybe some illegality, maybe something.
Correct.
Or maybe it was during the process of the
Well, they specifically
electionary.
mentioned there is a procedural lapses. Para 2, my lord, documents which has been produced. It was issued on 25th June, 2000, my last month. The Brahman has not agreed for issue of the LOA, rather asked that the retendering be resorted due to procedural lapse.
Procedural lapse, maybe this is because during the electioneering, we
Right.
do not know. That may be another cause because this matter had processed during the when the force was the more this code of conduct was in force. So necessarily that may be another reason.
Correct.
We don't know the reasons at this moment, right? So obtain instruction in that regard.
Right.
No, I will pay, but till them a status quo may be maintained because otherwise they will issue NIT. There is every apprehension. Moment I will, if in the evening they have issued this letter, my lord. And if there is every possibility, my lord, within a day or two, my lord, they go for NIT, my lord.
Heard Mr. Arish Mishra, counsel for the petitioner. And Mr. M. Katur, Deputy SGA,
For all respondents.
for all the official respondents number 1 to 3. For the petitioners, 1, 2, and 3. An NIT, in NIT issued by the chief engineer. Mr. Mishra, where is it? The NIT, just now.
Look, Please start from page 13, my lord. Page 39 is the necessary particles are there, page 39.
Where is the NIT starts
It
from?
starts from page 13, my lord.
Is 30?
1-3, my lord. 13.
No, it's not shown something, it's not 13.
And lordship, page 39 is a part of this, my lord, tender document, page 39.
Issued by the Chief Engineer Project Brahmank. BRAHMANK, care of 99 APO. For execution contract for surfacing work, preparation of subgrade. You just see page number 39. Might have this mark for this. Why this integrity agreement between you and the
It's a,
authorities?
it is, I have annexed the entire tender document, my lord. It's a part of the document.
This was issued when?
Well, issued on 24th of August. Lordship will find it page
Issued on-
39, that is there, my lord.
Issued on 24/08/2023. The petitioner along with other widows participated. As the petition, as during the process, the petitioner was found to be a responsive bidder as well as an L1 bidder on opening of its financial bids. The respondent authorities by communication dated 16/05/2024 within bracket Annexus C requested the petitioner to extend bid validity of the tender amount deposited by it for further extension up to 20/07/2024 from 20/03/2024. From 2024. Further extended from 20/05/2024, which was earlier extended on 20/03/2024. By this petition, the petitioners have prayed for a direction to finalize the said tender issued on such and such by reference number CE within bracket P bracket close BMK-08 of 2023-24 within bracket second call dated 23/08/2023. During the deliberation of the matter, Mr. Mishra also placed a communication dated 25/06/2024 issued by the superintending engineer within bracket civil on behalf of the chief engineer. Oruna Satasanswara Diva, Project Brahmank, intimating him that the authorities concerned has not agreed for issuance of letter of acceptance from the petitioner and has asked for retendering the said procedure as the earlier tender process lapsed due to procedural defect. But they said communication dated 25/06/2024, the respondent authorities also informed the petitioner that even the NEH did not agree for issuance of letter of acceptance to the L1 Bidarai, the petitioner, and directed the project Brahmang to expedite retender action. As for the letter of the headquarter concerned dated 18/06/2024. Issue notice before that one writings. It has been stated before the court by the petitioner that as the financial bids of the responsive bidders have all been already opened by the respondent authorities, the tender amounts have been made known to the bidders. Full stop. Issue notice. Tender amount for the said work noted above. Issue notice returnable by how many time? 5 weeks or 6 weeks?
4 weeks time.
4 weeks will do? 4 weeks. As Mr. Kato Sasenses accepts notice on behalf of all the respondents, no formal notice need to be issued. Petitioner shall serve requisite extra copies of this petition, including the annexes appended thereto. Copy of the communication of the respondent project Brahmang dated 25/06/2024, issued under number 80294/Brahmang/3/E-8, placed before the court today, communicated to the petitioner through email.
My lord, through email. Yesterday it was sent in the evening, my lord, around 6:30 around.
Mail or email?
Email, sir.
Through email. Placed before the court by Mr. RS, Mr. Counsel for the petitioner. Be kept as a part of the record. Without the leave of the court, the respondent authorities, including the project Brahmang, shall not retender such and such and such and such. Okay.
42 is the similar, my lord.
Project is different.
Project is different, my lord. Respondent are same, my lord. Issue is same, my lord.
Okay.
Only, my lord, one thing is there, my lord. In item number 42, my lord, I could not annex the copy, my lord, whereby we have to extend the validity period. However, we have extended, my lord. I have annexed the letter whereby we have extended it, my lord.
My lord, may I phrase it, my lord, in the, my lord, since lordship is,
Without the leave of the court, there is no stay. You obtain, place it before the record why you need to extend it automatically. You obtain the order from the court, nothing else.
But date of NIT is different, my lord. Here, date of NIT is 25th of August, my lord. Page 39, my lord.
Only next lecture. Page number 39, side level. 39, next.
Comparative charge 157, my lord. And our bill validity is at page 158, my lord.
157.
157 is the comparative chart, my lord.
Then
And my lord, the letter, my lord, page 158, my lord, whereby we have extended our validity till 21st of July, my lord. We have extended, my lord.
No, here you have asked for extension.
Yes, here. The communication, my lord, could not be annexed in the earlier petition, my lord. The communication have annexed the 16.5, my lord. Here also the communication was of 16.5, my lord, but the client misplaced it, my lord, in his file actually. So could not annex, my lord. But same in similar manner, we have been asked to extend the validity. We have extended, my lord.
You have extended now.
Yes, my till 21st of July. It is 158, my lord, is clear, my lord. Page 1 in the bottom, at last, my lord, we have written here, my lord.
Kindly read them.
Therefore, I would like to request you to kindly extend the validity for the.
You are requesting the authority to extend the validity. It is not on the request of the respondent authorities that you have done
My
it.
lord, statement I have made it paragraph 7, my lord, that we have been asked, we have extended, my lord. Paragraph 7, I have made a statement, my lord.
On being asked. You have extended the validity up to 21st July.
Yes, my lord, 21st of July, my lord. And my lord, the communication is also same with regard to my lord earlier 41. In that communication, my lord, same, my lord. Both, my lord. Both the work has been quoted here, my lord. First and second, my lord.
Fine. Previous file. Yes, okay.
My only submission is that since altercation and modifications, if the department is required.
No, we are not on that. Just same order will be followed. You place it before the court the reasons for cancellation. That's all. That is why the apex court has heavily come down on this. Many cases have been direction is given. Go through those judgments, you'll be knowing, Mr. Kato. Only because the rates are once made known to others, it will be easier for them extra. Right. So you have to have a valid reason for cancellation of that. That is why the Honorable Apex could have considered that aspect. In fact, in certain cases, the Honorable High Courts did not interfere in their writ petition. And then there are certain cases where interfered, so parties were to the Apex Court, but the court has dealt the issue very clearly. Yes.
Deeply above.
Malad, I'm very sorry, Malad. In this matter, Malad, I have received the fair-wise comment from the department, Malad. Some more time may be granted, Malad. We are under process for the filing of the the necessary reply, Malad. Now, department is very active, Malad. They are very alert now, taking Malad the issue very seriously, Malad.
It required my lord's order, 17.6 order now for them to wake up.
Under the Malad, unfortunately, I was not present. We'll be filing our affidavit.
See, what we have seen in some of the departments, particularly in this organization, since they think they are looking at the defense, they can do anything. That's not the case.
Welcome with the entire team.
Heard Mr. Deepangi counsel appearing for the petitioner. As well as Mr. M. Kato, Planet Deputy SJ, for the respondent number 124. 124.
Yes, ma'am.
Also heard MSGAT. Assam, sorry, Arunachal Pradesh. For the respondent number 5 and 6. 5 to 7. Mr. Katu, Planet Deputy SGA. submitted at the bar that he has received the pairwise comment from the respondent numbers 1 to 4 and shall file affidavit on their behalf. Give us a date, Mr. Kato. Give us a date when you file your affidavit. Not beyond 22nd. Make it very correct.
31st July.
No, that cannot be. That's why I said 22nd July. We have already given.
Yes, ma'am.
Give us a date in
Just
between,
immediately after vacation, ma'am.
not after vacation. So that is why we are saying within 22nd of July you give us. 22nd of July on any date. But you have to file.
My lord.
Okay, 22nd of July.
My lord.
Submitted that the affidavit on behalf of the respondent number 4, 1 to 4 shall be filed on or before 22/07/2024 without fail. Considering the same, considering the prayer on behalf of the Sonapur paid by Mr. Kato. Such time is granted to the respondents number 1 to 4 to file the affidavit. Such affidavit shall be filed by the respondent numbers 1 to 4 on or before 26, having a copy of the same on the counsel for the petition list on 24th. July.
Diplomat.
Your Lordship, I pray that I may be allowed some more time to file our affidavit, Your Lordship.
See, granting time, what is happening, what we have noted here is the orders, it's sometimes we can see it's more than the writ petition. Any difficulty, the departments are not listening to you or not cooperating with you, not providing in the relevant pairwise comments to you.
No, Your Lordship.
Is there any difficulty?
No, Your Lordship.
Then why are you not getting the instructions in time? It is, you are representing which department?
Here, Your Lordship.
We can understand in the state of Arunachal Pradesh, terrains are different or, but if the thing is in the Itanagar, then why will you not receive the instruction? If it is from the director, executive engineer, what is the difficulty? Places from far enough, we can understand, we can consider. And that is, see, the notice was issued in August 2023.
Yes, Your Lordship, I understand, Your Lordship.
So, who is obstructing?
No one, Your Lordship.
If nobody is obstructing, then why the delay?
Your Lordship, this bill has been pending from since 2009. It's more than a decade now.
See, what will happen, you know, ultimately the public will be the losers. Ultimately, you will pay at one point of time because of the court's order or whatever.
Yes, Your Lordship.
Now, tomorrow, if there is any interest amount, it is the public money.
Yes,
And
Your
if you don't deal with that matters little seriously, then what will happen?
Your Lordship.
Give us a date. Give us a date, that's all. That you will file by that specific date. But it should be in the month of 3rd week of July.
Your Lordship.
Don't tell me in 29 July, 30
No,
July.
Your Lordship.
Give us a date.
By
Specific
26.
date.
26, Your Lordship.
You will file,
Yes, Your Lordship.
put his name, put their name. Submitted the bar, the affidavits on behalf of the respondent shall be filed on or before 26 July without fail. Okay. Since notice in this case was issued on 02/08/2023 and considering the claim of the petitioner pending before the respondent authorities for the period from 2008-2009 and 2009-2010, no further time shall be taken to the respondents to file their affidavit within bracket smallest. Beyond 26/07/2024. Placed on 31st July.
Congratulations. Let's see.
My pleasure, Lordship.
Yes, Mr.
Here,
After long time. Yes.
Respondent 1, 3, and 4 yet to file affidavit.
What is your claim here?
This is a matter pertaining to eviction.
My lord, in this case, my lord, I've informed that the DMO has been made a party, but I've not been served with a copy as today, my lord. Even at the time filing, no notice was given.
Notice was received
No.
by the government advocate on behalf of all the respondent at that time.
If DMO is the party, my lord, they should have served a copy before filing.
Where is the eviction order?
So eviction order is 10/10/2023. Lordship, actually, this morning I came, due to which I misplaced my file.
Doesn't matter.
So I could not pick up my original file. Wrongly, I have picked up some other file. So otherwise also, so Lordship, here respondent number 4, 3 and 4 is very necessary to file affidavit.
You are appearing from medical respondent number 4.
My lord, yes, just now I come to know that DMO has been made party, my lord.
Who is appearing for estate officer?
Lordship. Lordship, affidavit filed by DC will cover.
Only 2 has filed affidavit.
2 and 3 is the common, I think. So there
Lordship,
should not be any. What is the stand of the land management department?
So here, eviction notice issued by ADC Malo. So our affidavit will not be required. We will be relying on the affidavit filed by the DC. Go ahead.
Yes, you are representing the government.
Lordship.
Yesterday late evening while returning to our bungalow, just for your information. After crossing the Hatimatha and then turning to our bungalow, just at a glance, on the road itself, there is somebody is constructing a staircase. Staircase has been under construction to go to the upstairs. On the road. Tomorrow there will be a full-fledged construction. It will be made ready. Then thereafter tomorrow, certain point of time, when we will have the new High Court building, we requiring to widen that road, right? What will you do? Then there will be notice because unauthorized construction. Somebody will appear before the court, this court only. There will be stay like this. And now, you see, the administration is working in similar manner. Even if you go today, you will see that is under construction. The day when I came here, it was not there. Immediately rain stopped, they have started doing. It was not there only. Yesterday, we found that only bamboos and everything, they started under construction. If you go there, you'll see today. Just on the corner when they're taking turning. If that is the administration, how will you manage? Here is a road to go to a particular hospital. Right? Petitioner is occupying government land. Notice issued, there is a stay from the court. What action? That's why on that day also I have repeated, there is an order of His Chief Justice Supreme Justice A.K. Goswami. It's a reported. It's a case from Arunachal Pradesh. When His Lordship visited Arunachal Pradesh, it was pointed out to him what kind of cases were there. It was pointed out before us. I was there at that point of time. Then certain matters, His Lordship came again and passed an order. It's a division bench order. After the order passed by the learned single judge, it was appealed before the division bench, and division bench passed an order. There, the lordships have specifically mentioned should take out that order. They have restrained the state, the learned single judge, because in that case, there was no stay. Direction was given to dispose of the appeal by the deputy commissioner disposed of the appeal. Right? Allowing the order of the, approving the order of the state officer. Because it's government land. Should take course of those orders. You should have those orders in your hand to place it before the court, before passing any such stay order. Here the appeal was pending before the deputy commissioner, right? The deputy commissioner, at best, at that point of time, you would have prayed, because instead of matter being pending here, the deputy commissioner should have disposed of the appeal at the earliest.
Exactly, ma'am.
What is there to be stayed, right? At a certain point of time, the court may pass an order, stay order. We are not on that order, but immediately next date, when you have seen the matter is pending, in appeal stage before the deputy commissioner.
Appeal was disposed in
In the favor of the state.
That the appeal was disposed ex parte.
Then what next? Send back the matter to be reheard. But that doesn't mean that the stay will continue for so many time.
If expert, they will be given opportunity.
Because the party prayed before the deputy commissioner that his counsel is sick. He could not attend the court. In that circumstances, deputy commissioner has disposed of the appeal. Is not it? So, we'll remand back the matter.
Exactly.
Remand back the
No
matter.
use of keeping pending.
What's the matter of keeping pending? Mr. Boze will send it back. Let the appeal be heard by the deputy commissioner.
Lordship, may I submit?
Yes.
Since I am not having my file
Brief.
also.
Second brief is available. Give it to him. Give him the second brief. We'll get that order at page, the order of the deputy commissioner.
So here, my
Yes, come to page number 33.
Lordship,
Page number 33. Annexure F.
geo coordinate satellite imaging.
That the order at Come to page number 38 now.
38.
Then 39.
38. Oh, there is no order.
Page number 39.
30,
39.
38 is this election.
Annex should be there. The last page of the petition.
Okay. Sorry. Thirty-nine, Lordship.
Yes.
Yes, this is the interim order.
Kindly read.
Order. This matter came before me due to an appeal filed by Sri Nyasham Jongsham under section 12 clause 1 of the Arunachal Pradesh Public Premises Eviction of Unauthorized Occupant Act 2003. The case was scheduled for hearing today at 11 hours, but due to some administrative reasons, the timing was refixed for hearing at 1500 hours, mainly owing to urgent nature of the case as such. Its timely disposal is imperative. The petitioner was duly informed of this updated timing, but failed to appear before the undersigned despite receiving a copy of the order, and rather submitted another prayer seeking a subsequent date of hearing on 24/10/2023. The matter of fact that the section 12 clause 4 of Arunachal Pradesh Public Premises Eviction of Unauthorized Occupant Act 2003 recommends for prompt and expeditious disposal of appeal, and bearing in mind the expeditious nature of the case involving public health delivery being affected owing to non-availability of house route, and also considering that any further delay in disposal of this case may jeopardize the public health on account of the delay in starting of hospital building. The opportunity of subsequent hearing to the petitioner is not granted. Copy of order enclosed as Annexure S. Upon careful reviewing the written submission made by the ADC State official, Changlang, established that a joint seat inspection had been conducted for the construction of approach route to the new district hospital building. During this inspection, it was found that the petitioner had constructed an SPT building on the approach road issued to the appellant under section, approach road, and no allotment had been granted to the appellant at that seat. Consequently, a notice was issued to the appellant under section 4 clause 1 and section 5 clause 1 of the Arunachal Pradesh Public Premises Eviction of Unauthorized Occupant Act 2003, directing him to vacate the illegally occupied government land. The land in question is government owned, and the appellant is unlawfully occupying and encroaching upon it by Annexure B. But I have examined the report submitted by the DLRSO Changlang, which contradict the petitioner's claim that the structure of the building have existed since 2009. 9. There is no substantial evidence to support the claim of the historic possession as asserted by the appellant, and the erection of the subject structure is of recent origin, as verified through periodic satellite imaging. Having carefully considered all the facts and records presented before me, it is evident that the ADC state officer, Changlang, has duly followed the procedure outlined in the Arunachal Pradesh Public Premises Eviction of Unauthorized Occupant Act 2003. In view of the above findings, I hereby reject the instant appeal petition filed by the appellant petitioner, Sri Nyasam Jongsham. The ADC state officer Changlang is directed to proceed with the removal of the encroachment in accordance with the provisions of the Arunachal Pradesh Public Premises Eviction of Unauthorized Occupant Act 2003.
Okay.
So my measure.
We'll take care of it. Heard Mr. D. Bose, counsel for the petitioner. Mr. D. Kamduk. Mr. D. Kamduk, Planet Standing Council Land Management Department for the response number 1. Also heard Mr. Land Government Advocate Arunachal Pradesh for the respondent numbers 2 and 3. And Mr. Titagum Learned Standing Council Health Department for the respondent number 4. As the petitioner was found, Mr. Bose, you say, in illegal and unauthorized occupation of government land comprising an area measuring about 154 square meters in bracket 11 meter into 14 meter. Constructing and developing the said land with structures on it without any authority, prior approval from the competent authority. And written permission. The state officer, Changlang headquarters, district Changlang, on 10/08/2023, after inspecting the site, issued notice to the petitioner under the provisions of Rule 2 within bracket small Roman 4 of the Arunachal Pradesh Public Premises within bracket Eviction of Unauthorized Occupants bracket close Act 2003. Issued notice under Rule 4 within bracket small Roman 1 of the Arunachal Pradesh Public Premises Eviction of Unauthorized Occupants Act 2003. I don't write rule, section 4, you write section 4. Finding it to be in violation of section 2 within bracket 4 of the said 2003 Act. giving an opportunity to the petitioner to show cause as to why eviction should not be carried out on the said illegal and unauthorized occupation on government land. In the said notice issued 10/08/2023, the state officer Changlang categorically stated that said illegal construction over unauthorized occupation of government land is near the ongoing new district hospital construction site at Changlang. After hearing the petitioner, the state officer Changlang on 19/09/2023 passed an order under section 5 of the section 5 within bracket 1 Roman 1 small Roman 1 under the said 2003 Act, directing the petitioner to vacate the said government land under his illegal and unauthorized occupation within a period of 15 days from the date of issue of the said order, with intimation to him, intimating him further that in the event of his failure to comply with the said order, the state officer Changlang will evict him from the government, him and his person, from the said illegal and unauthorized occupation of the government land, and shall take possession of the public premises by engaging necessary employees and force. Against the said order of the state officer dated 19/09/2023, the petitioner preferred an appeal under section 12 of the 2003 Act before the Deputy Commissioner Changlang. On the date fixed of the appeal, on 6/10/2023, the petitioner as an appellant could not appear in the appeal as because of his ill health of his counsel. As such, the Deputy Commissioner, being the appellate authority, fixed the matter for hearing on 10/10/2023 at 11 hours, either in person or through legal counsel, intimating the petitioner accordingly. On 10/10/2023, the said hearing on the appellate authority, Deputy Commissioner Changlang, could not hear the matter at 11:00 hours as it was fixed on 6/10/2023 and refixed the same for administrative reasons and refixed the same on 10/10/2023 at 03:00 PM. While the matter was taken up for adjudication by the Appellate Authority Deputy Commissioner Changlang, the petitioner neither the petitioner nor his counsel appeared in the matter. Rather, submitted an application seeking further time up to 24/10/2023. However, considering the earlier order dated 6/10/2023 and proper intimation to the petitioner on 10/10/2023 of refixing the matter at 03:00 for 15 hours. And further considering that the requirement of an approach road, newly constructed hospital at Sanglang being utmost public importance and urgency, and that the petitioner is in illegal and unauthorized occupation of government land near the said newly constructed hospital. The Deputy Commissioner Changlang on 10/10/2023 passed the order on examining the reports of the estate officer and directed and rejected the appeal of the petitioner, upholding the order of the estate officer dated 19/09/2023. Agreed by the said ex parte order of the Deputy Commissioner Changlang, i.e. the Appellate Authority, dated 10/10/2023, the petitioner preferred this writ petition. While issuing notice to the respondents, the court in the interim, while issuing notice to the respondents, the court on 13/10/2023 in the interim passed an interim order staying the impugned order dated 10/10/2023 passed by the Deputy Commissioner Changlang, being the Appellate Authority under the provisions of the said 2003 Act. File number C/AUD/MISC within bracket appeal bracket close number 03/2023, which is still in force. The respondent numbers 2 and 3, representing the Deputy Commissioner Changlang as well as the Estate Officer Changlang, filed their affidavits in the matter on 08/02/2024 to which the petitioner did not file any rejoinder till date. Mr. Tagum, Learned Standing Council, Health Department, submitted that though the district medical officer Changlang is a party respondent number 4 in the present proceeding, he being the standing council, copy has not yet been served upon him. Mr. Kamduk, Learned Standing Council for the Land Management, submitted as the Deputy Commissioner Changlang and the Estate Officer Changlang, respondent numbers 2 and 3, have already filed the affidavit in the matter. The respondent number 1, Secretary Land Management, shall support the case of the respondent number 2 and 3. On perusal of the order dated 10/10/2023 passed by the Appellate Authority Deputy Commissioner Appellate Authority under the provisions of the said 2003 Act, Deputy Commissioner Changlang, it can be seen that the said order was passed without hearing the petitioner. It is also seen that said hearing was initially fixed at 11 hours on 10/10/2023 as per the order dated 06/10/2023, which was subsequently postponed up to 15 hours on 10/10/2023 by communication by order dated 10/10/2023. After hearing the learned counsel for the parties and considering interest of the matter, this court is of the view that as the order dated 10/10/2023 passed by the Appellate Authority Deputy Commissioner Changlang in C/ZUD/Miss MISC within bracket appeal number 03/2023 was passed without hearing the petitioner, opportunity may given to him, i.e. the petitioner, to appear before the Deputy Commissioner, Deputy Commissioner Changlang, the Appellate Authority. And the Appellate Authority under the said 2003 Act, Deputy Commissioner Changlang, shall dispose of the said such and such case number after hearing the petition. As such, the impugned order of the Deputy Commissioner Changlang issued on 10/10/2023 is set aside in post. As the petitioner is represented by his counsel, as well as the respondent number 2 and also being represented by the State Council. Before that, you write one sentence. Accordingly, the petitioner shall appear before the Deputy Commissioner Changlang in case in C/ZUD/Miss within bracket appeal number 03/2023 on Mr. Buzatil Assam which date in July, which date he shall appear before the Deputy Commissioner. Date. You give us a date in the month of July.
Lordship, I may be given reasonable some dates.
Definitely, give us a date. Okay, give us at least today is 27th, 26th. So give us a date sometimes around a week commencing from 22nd.
Maybe given on 26th.
Not on Friday. Because 27 again is a Saturday.
Then Lordship, it may be given on the, in the.
24th, the petitioner shall appear before the Deputy Commissioner Changlang.
Lordship, 24th, it coincides with my other cases also, that Lordship.
You will appear.
So
You will appear for the petitioner. You will appear before the Deputy Commissioner as a counsel of the petitioner.
here, I have a matter at on 24th at here at Session Court, so.
No. When will you appear before the Deputy Commissioner Changlang? Will you represent the petitioner before the Deputy Commissioner?
Yes, it may be on the 7th,
23rd?
7th of August.
No. Can't be. Already matter is pending since 23. So we are not extend further time. You appear in any date between 22nd to 24th
22nd,
or 25th.
22nd to 24th. Lordship, it's a very hard. I have already fixed matter, Lordship.
Can't help it. You have to, these are eviction matters. You have to forego something in that case, if you are appearing.
It maybe fix on then that on
22nd.
23rd.
23rd?
Yeah.
Fine. On 23/07/2024. Before that, one more line only. It's remanding back the matter to the appellate authority. Thereafter, you let, as such and such has been passed in presence of the counsel for the petitioner, as well as the standing as the government advocate representing the respondent number 2 and 3. No formal notice need to be either to the petitioner or to the state officer. Changlang, respondent number 3. The petitioner, either personally or through his counsel, shall now appear before the Deputy Commissioner Changlang, the appellate authority, under the 2003 Act, on 23/07/2024 at 11 hours. The Deputy Commissioner shall dispose of C/JOD/Miss Appeal number 03/2023 by hearing the petitioner or his counsel on such and such, and shall pass order accordingly under the provisions of the Arunachal Pradesh Public Premises within bracket Eviction of Unauthorized Occupants bracket close Act 2003. Copy of this order. The registry shall forthwith furnish a copy of this order to the Deputy Commissioner Changlang for his necessary compliance. The above observation, this application.
Lordship, my only one submission is that since my submission also may be recorded, Lordship, only one line.
Yes.
Since respondent number 4, his affidavit is very important. Lordship.
This is before the eviction
Very
matter,
important.
before
He
the different
His
authority.
affidavit is not required at all.
No,
Because there was an inspection. That inspection report is available. You have annexed.
no,
And that
Lordship,
inspection is done. And remember, we'll put one line here. Any illegal and unauthorized occupation over a government land, any construction done over the government land, illegal or unauthorized construction, for a long period, even if you are residing on it or occupying it, will not give you any such right to settle with that land.
but here, Lordship,
It is the government who are benevolent enough. Tomorrow you can occupy any government land inside this
Lordship,
particular campus.
since,
Let us assume, we have seen how the land of the library has been occupied by people in the highest authority. Right? 2 days back we have seen. Now similarly, that is also I feel was interesting. The council representing the state is saying only few areas of land, few square meters. It may be few, it may be huge. Where is the authority? Where is the authority? Can somebody be allowed to occupy government in such manner? Anyway,
No, Lordship.
there is the law, even if somebody occupies a land, government land for a long period, unauthorizedly and illegally constructing any such building, whatever. Right?
Right.
Today, let us assume occupying the land of this court. There are many other areas occupying this land.
Lordship, I have
No,
already
no,
applied.
let us, applying will you give you the right to occupy?
Uh,
First you apply, get the permission, then you enter and occupy.
Actually, Lordship, here the
Where is
fact-
the right? Where is the right? Just tell
here
us.
the fact of
Which is the
case that-
law? Which
Lordship.
particular law, Mr. Boje? I don't, and this is for all. Which particular law provides that you will first enter, you will illegally occupy, you will construct, then you will apply and get the permission? Is that the law, or it is the law that you will first apply, you will get the permission, then you will enter and occupy and you will construct?
Long back I have applied, Lordship.
Then your application is prior to enter or before entering the government land?
While occupying, I have applied.
Whether government gave you any permission?
Nah.
Whether gave you any permission?
At that relevant point of time, they have not seek any permission. Ask me any permission.
You need to seek permission, or it is fully, if there is a vacant land, you occupy?
No,
You
Lordship,
occupy then
only-
fields of the government.
Only fact is that since the respondent number 4 with the district medical officer.
Your case is dismissed in that case. If you are going to argue, we'll dismiss your writ petition. You are getting an opportunity, you want to take it, otherwise we'll dismiss. Because in the affidavit, you have not filed any rejoinder, there is a note, there was a joint inspection. Mr. Boje, you have not filed any rejoinder. And very clearly, there was a joint inspection. Joint inspection discloses that you are occupying government land. We'll dismiss it.
I'm
Reverse
extremely
the order.
sorry, Lordship.
We can reverse the order.
I
You say, want to argue? Yes, you argue.
No, Lordship, just I took permission of the honorable court for filing a rejoinder, but.
You have not filed rejoinder.
Yes,
So
so I was supposed to file.
if you have filed rejoinder, even in that case, there's joint inspection.
So since I have been waiting for their affidavits, actually.
It's up to choice is yours. Want to take it option or we'll dismiss it? Choice is yours,
My
Mr.
request-
Boje at this stage.
Request was, I have to be heard, that's all.
That much you have given an opportunity. We are remanding back the matter to the Deputy Commissioner for rehear. If you want to take it, otherwise we'll dismiss it. Up to you. Next.
Then Lordship.
Yes.
Lordship, I have received the affidavit filed by the responding authority where they are admitting that the corrigendum letter issued from the housing director was reached in the office after passing of interim order. So my writ petition before the Honorable Court is to set aside and quashing the interim order passed by the Deputy Commissioner Itanagar dated 15/6/2023 on the ground that while passing the order dated 15/11/2023, the complainant Director Housing issued quite a notice dated 6/11/2023, whereby my name was prayed for delayed from the complaint encroacher list. So despite of issuing this corrigendum letter, the learned Deputy Commissioner did not
Which
admit
letter?
the page number, my petition annexure 4
Page number?
page number 19, annexure 4 is interim order. the page number 20 is the last operative portion. The appellant Lika Raj is directed to remove the illegal unauthorized structure near the government quarter number 40 and 41. Type 3 at H sector Itanagar within 15 days from the date of issue of this order, failing which the eviction shall be carried out by the ADC state officer, and the cost of removal / eviction shall be recovered from the unauthorized occupant. This is the imping order. Kindly peruse the next page, page number 21, Annexure 5. This is a corrigendum letter issued by the complainant Director of Housing, dated 6/11/2023. Here clearly mentioned that I have not my
Page
signature is
number
not
21.
connected with.
Director of Housing, yes.
Yes, white letter number so and so dated so and so name namely Sri Lika Raj name was wrongly enlisted as illegal encroacher government quarter number 1441 type 3 H sector Itanagar. On re-verification, it has been seen that government quarter number 40 and 41 type 3 at H sector Itanagar intact and free from any hindrance. Hence, it is requested to kindly delete the name of the Lika Raj from the list of the database of encroachment. So this corrigendum issued on 6/11/2023 and impugn order was passed on 15/11/2023. And in the before passing of impugn order, the corrigendum letter is already issued from the Director and Housing. So in their affidavit filed by the responding authority here also admitting that while passing this impugn order, both the complainant and the petitioner was present. So if the complainant was present, the corrigendum letter must be present before the Deputy Commissioner while passing the impugn order. So my prayer before this Honorable Court today.
Now, where is your reply to the show cause? Where is your reply to the show cause?
So cause
Have you annexed?
that is my lord, that is
Where is it?
well issuing so cause the order EAC Itanagar order is the 7/3/2020 was passed.
That's right.
In yes, in after passing of this order dated 3/7/2023, I appeal before the Deputy Commissioner.
Where is your show cause reply? Why you have not annexed?
Yes, in my writ
Where is
petition,
it?
so cause notice is not.
Why it is not good?
I have not been provided by the client. So
Your client is very intelligent.
uh,
Apparently intelligent because you see.
only my impugn order is the order dated.
That's the reason. The impugn order of the state officer was of 3rd of July.
No, 15/3. 15
3rd of July.
Passed.
The Deputy Commissioner passed the order on 15/11.
Yes, yes,
And the order of the state officer is on 3rd of July for eviction,
yes,
right?
yes, my lord.
Now, read page 17. Para 4.
It is viewed that the
No,
construction
before
of
that,
Yes.
before that, the paragraph before that.
the opposite party so and so stated that he is having no land allotted and staying in the said premises since 2010, and also he informed that he had applied land allotment in the office of Deputy Commissioner Itanagar and he is ready to remove the encroached portion. If encroached.
If he is not, if he has encroached and he is ready to what? Remove the encroached
Yes, if
portion.
encroached, yes.
Where is the word if?
There is no such kind of encroachment.
Where is the
here.
word if? That is why your client is very intelligent.
My lord, is still
That is why he has not submitted, he has not annexed his reply.
yes. My lord, being a law abiding, still I am ready. If I encroach, I am ready to remove. After spot verification,
Get the,
there is no such encroachment is there.
Reply, get this record from the Deputy Commissioner or the State Officer tomorrow.
Otherwise also, he doesn't have allotment. This is encroachment only.
We know that.
In between, this is.
What is happening occupation of a private land adjacent to this particular public premises. What he has done, he has encroached this land, the public premises land.
Yes.
So we want to see his affidavit. Intelligently, he has not annexed that so-called reply. Get it by tomorrow. That's all. It is available here only. This is from Itanagar. Hardly you need to give a call. You'll get the records tomorrow. Produce it. Day after tomorrow, the court may not sit because we have to reach Kolkata day after tomorrow. So I'll be here for some time, but we'll leave early. Get it. The record is hardly takes few minutes. Give the call. You'll get it tomorrow and see.
If the office is open till now.
Tomorrow 10 o'clock also, if you give him call, they will come. It's a court's order.
I understand, but then we don't get the officers.
You have to get it.
Most of the
It's
time.
not even 4.
Most of the time.
Office is up to 4:30, is not it so?
Understand also.
Then
They are, but
ask the head, they will open the file. That day we asked for a file. Our office people, even he, till 8:30 at night, walked in the old building and took out the file.
our court works that way, but then.
I am proud of my employees. I am proud. I go and every say the High Court the way works, it's fantastic.
Yes.
You don't get even in Assam or in any other state.
Yes.
They really works hard.
By 3, we don't get any office. So when
You
we-
try. Tomorrow. Don't wait, keep it for day after tomorrow.
The so-called reply, Lordship.
Yes, the so-called reply, you get the entire file from the deputy commissioner and the state officer, the same office.
Lordship, well, in that case, I may be given time to file additional affidavit to bring and record the so-called reply
We know,
filed by me.
we know. Let us see tomorrow. You get this file number DC/ICC/ZUD 01.
Lordship.
Okay, put this. Place this tomorrow, enabling the state officer, Itanagar Capital Complex, as well as the deputy commissioner, Itanagar, to place on record the file number DC/ICC/ZUD -01/2023, wherein the impugn order dated 03/07/2023 was passed against the petitioner by the concerned state officer.
Okay.
Yes. Yes, Mr. Rose.
Yes, also, Your Lordship, I need some more time, Your Lordship.
Well, in this matter, the community land was acquired for the hydropower project, that's called Italian hydropower project. And then the list
Where is
of,
the earlier order of the court? You said it's a court matter. Where is the order passed by the court?
Yes, Your Lordship, we have to see some instructions, Your Lordship. But I'm sorry. to say-
No, there's an order, the petitioner submitted.
order was that during the pendency of this writ petition, there's no bar to consider their cases matter.
When the land was occupied?
My lord, this is the community land, my lord. This is-
True.
Yes.
When the, whether the road has been constructed?
No, my lord, this is for the hydropower project.
Sorry, for this hydropower project, land has been taken over?
Yes, lane has been taken over. In fact, earlier the lane was for the project, the Jindal project. But then recently it has been taken over by SGBN. Yeah, it's similar. You'll also may see in page. I have just annexed the page 93.
Yes.
93. Let's start from.
No. Land was taken over for this hydropower project, is
Yes,
not it?
my lord.
When it was taken over?
My lord,
2015,
2000, my lord, I will just check to that award. 27, 2015.
Just a minute.
Notification of 22 October 2015. Well, may I please to see the award?
2013
Is
Act,
in
Land
page
Acquisition,
54.
New Act.
Page 74 is the details of that award.
Who is appearing for the land management? Yes, Kamduk, and you are appearing for the Deputy Commissioner.
Yes, Your Lordship.
Come to section 24 of the 2013 Act. Do you have an extra copy? Give it to me. Okay, we'll read for you. Listen carefully. Section 24 determines land acquisition process under Act number 1 of 1894 shall be deemed to have lapsed in certain cases. 1. Notwithstanding anything contained in this Act, in any case of land acquisition proceeding initiated under the Land Acquisition Act 1894, A, where no award under Section 11 of the said Land Acquisition Act has been made, then all provisions of this Act relating to the determination of compensation shall apply. Or when an award under said Section 11 has been made, then such proceedings shall continue under the provisions of the said Land Acquisition Act, as if the said Act has not been repealed. That is 1. 2. Notwithstanding anything contained in subsection 1, in case of land acquisition proceeding initiated under Land Acquisition Act 1894, where an award under said Section 11 has been made 5 years or more prior to the commencement of this Act, but the physical possession of the land has not been taken or the compensation has not been paid, the said proceeding shall be deemed to have lapsed, and the appropriate government, if it so chooses, shall initiate the proceedings of such Land Acquisition Act stamps land acquisition afresh in accordance with the provisions of this act. Provide that that where an award has been made and compensation in respect of majority of land holdings has not been deposited in the account of the beneficiaries, then all beneficiaries specified in the notification for acquisition under Section 4 of the said Land Acquisition Act shall be entitled to compensation in accordance with the provisions of this act. Now here is number 74. This is an award passed by the Deputy Commissioner Dibang Valley Anini on 28th of July 2015. This 2013 Act came into force in 2014, 1st January, I believe.
It came into force on 1/1/2013, my lord.
One
For
on
the state of Arunachal Pradesh.
For the state of Arunachal Pradesh, 1st of January 2013.
Yes, my lord.
For the nation, it has come into force from 1/1/2014.
Yes, my lord. Oh, sorry, my lord. 1/1/2014, my lord.
1/1/2014.
Yes.
Now, from this page 74, it is clear. Section 4 notification was issued on 27th of November 2012. And Section 6 declaration.
Your Lordship, if I may, Your Lordship may kindly turn to page 75, Your Lordship.
Yes, 75 will see.
The first para itself, Your Lordship.
Huh?
First para, 75, Your Lordship.
Kindly read.
The total area of land acquisition is of such and such, falling in the Devangeli district. Section 24(1)(a) of the Right to Common and Transparency Act 30 clarified that in case of any land acquisition proceeding initiated under the Land Acquisition Act 1894, where no award land under Section 11 has been made, then all provisions of this act relating to the determination of competence shall apply. Therefore, for computation of compensation procedure specified in first schedule of right to fair compensation and Resettlement Act 2013 have adopted in transfer so the acquisition has taken place. Later on we have rectified our mistake and we had awarded this in terms of 2013 Act, Your Lordship.
Of course not. On the basis of, you might have assessed the compensation, but the entire proceeding lapses. Where is the fresh notification as required under the 2013 Act? Can we act on those 2013 notification and the declaration? How will you act? In the 2015, you have passed an award. On the basis of that proceeding, you have initiated when the 1894 Act was in force, which has lapsed under Section 24. You are supposed to issue a fresh notification and declaration. Can you act upon an old notification and declaration when the proceeding has lapsed?
No.
Then, why the half part the Deputy Commissioner has assessed? You have assessed the compensation on the basis of the notification of 2013 and declaration of 2013. And you passed the award in 2015. That was what the 2013 Act Section 24 says. When it is lapsed, Section 24 is very clear. No award been passed. The proceeding lapses. You have to take over under the 2013 Act. And 2013 Act, you are supposed to issue fresh notification and fresh declaration. Where is that? Have you issued any fresh notification and declaration under 2013 Act?
Your Lordship, I don't have the instructions so far, Your Lordship.
That,
which is
see,
basic, Your Lordship.
by reading of that order itself is clear. How will you legitimize when the proceeding is lapsed under Section 24? How will you assess a on the basis of a notification issued in 2012 and 13?
Lordship. For that, I have to take instructions. Your
Why instruction? You are a lawyer. You know the provisions. From the reading of this order, whether it is reflected,
No, Your Lordship.
then
My lord, in fact.
yes, sir, I don't know how the land management department is working in the state. See, you have read this order of the deputy commissioner
Yes, my
of
lord.
2015.
My lord,
Look at this, the contentions. No registered deeds are available.
my lord,
That's how the process, the land value will be on the which date? On the date of the notification.
yes, ma'am.
Proceeding lapsed. Where is the new notification under 2013 Act?
That is not there in the writ petition, my lord.
There is no new notification.
Maybe-
Proceeding lapsed means you have to initiate afresh.
Yes, my lord.
Where is that?
My lord, that is
In
the
this
from-
particular award, there is no mention that the fresh notification was issued.
No, no mention.
Then even this award is lapsed.
This is my lord, there is a miscommunication between the deputy commissioner and the government.
We are not on any miscommunication. This particular order is absolutely clear.
Because my lord, deputy commissioner ought to have write a letter to the government.
How
to
the government,
issue-
how the land management has approved this award? Tell me how the land management department has approved this award? Don't blame the deputy commissioner. At the same time, it is also the duty of the land management department to write it back to the deputy commissioner to initiate a fresh proceeding. Mr. Come to page number 75, first paragraph clearly is that you have approved the rate in the year 2014. Just right. You have to rise in the resume. Matter relates to acquisition of land for 3097 MW, it's megawatt, but right MW. Italin ETALIN, that's hydro electric project. In the village of, is Yaro Apai is our villages or it is the community?
My lord, Akobai it's in page 52. Two location were here. In page 52 and page 56. The two location was, this is a community land. So,
Community
then
land
what-
is right. Where is the land? Which area? That is the mention in the order. Please come to page number 74.
location, my lord, is only plot number.
Mr.
is
More
in-
the see, please the first paragraph. Of community of Yaron, Apai, Aguli, Aso,
Akobe.
Akobe.
Akobai is. This is the land of Akobai.
Akobe is the community or the village?
This is Akobai. Akobai is the name of the village, but then the land belongs to the Akobai village. Belongs to the Akobai villages.
Chance slip. I'm just putting the marks, page number 74. Land measuring 833.51 hectares
The
and 208 hectares.
contention of petitioner is that they are also from the Akobai village, but they are not in the list. They have
Okay.
prepared the list, but they are not in the list.
In these villages, I have just marked page number. Okay. of Anini Circle, Italian headquarter, Atei, Afunil, New, we put everything here. I'll check it out, no problem. Of Dibang Valley District, Arunachal Pradesh. There are two districts. Anini Circle and Dibang, Italian Circle of Dibang Valley. District is one, it's two different circles. The contention of the petitioners herein are that though they belongs to Akobe village and their community land has also been taken over for the said hydroelectric project, they have not been paid compensation.
They are not in the beneficiary list, my lord. They are not in the beneficiary list.
Their names are not in the
Not in the beneficiary list.
Not in the list.
List, my lord, that's what. They have prepared the list, but then their names are not in the list. That is
As
the
their
issue.
names are not in the beneficiary list. Though their community land has been taken over, this community land will come later. Community land has been taken over at village Akobe for the said hydroelectric project. From the communication of the Deputy Commissioner, Dibang Valley District, Anini, number DVA / CC -194/14-15 1860-63 dated 20/07/2015. Page 74 to the petitioner, part of Annex 9. No, you can write forwarded by the Deputy Commissioner to the Land Management Department on 20/07/2015. Annex 9 series, page 73/74-76. It can be seen that okay, we'll complete the order. Since we have an interview at 4:30, you have to rise. And we'll give you some time to both Deputy Commissioner and the Land Management Department. We'll fix it sometimes in the week commencing from 29th, 30th or 31st, we'll fix it. You have to tell us, 31st July. We'll fix it. You have to tell us how you have given the approval.
May I please, your lordship? Your lordship, I beg to mention item number 14, your lordship. It was a fixed matter for today, your lordship. Can this be taken up tomorrow, your lordship?
What is the matter about?
This was a matter regarding the suspension of the termination order, your lordship.
Termination of suspension order.
Termination of suspension order, your lordship. Termination of the suspension order, your lordship, of the petitioner.
That matter where there was no review.
No review, your lordship. There was no review.
My lord, that is regarding charge sheet was already sub, my lord.
That
Now
is what-
proceeding is going on, my lord. They should don't even it is not reviewed, my lord. It is not a case. This is 90 days in the case where the charge sheet is not given us.
Is that correct?
My
That
lord,
is why in the first half we have mentioned
my lord.
what is the order in the CCL, you find out. Mr. Panging case was there, we have.
Yes, my lord, that is in serious, even Ajay Kumar Chaudhary also in our division bench also, my lord, it's in respect to where charge sheet.
Look at the judgment of Justice Goswami reported in the ZLT.
And
That has
my
been
lord,
approved.
recently Justice Sandeep Mehta, Chief Justice, and the Suman Sam order also there. My lord, this regarding if it is not reviewed, in case if the charge sheet is not there, my lord. Here in time, charge sheet has been filed, my lord.
So a person who is in the disciplinary proceeding is going on, he should remain in suspension.
My lord,
Tell us, you want to say that if.
my lord, there's a period, my lord, subsequent to
Mr. Tagum, your statement is like this. If a person where disciplinary proceeding is going on, charge sheet is filed within 90 days, so the order of suspension need not be reviewed and he should be allowed to continue in the entire proceeding of
my
disciplinary
lord, it's
proceeding.
not,
Suspension.
my lord, recent 2022, my lord, the CCS rule has been amended according to 2 years, my lord. 2 years it has been framed, my lord, extended, my lord. 2 years.
Without
Yes.
without review.
my lord, review, in case it is not, the review is applicable where there is no charge sheet has been, my lord, filed. But in case if a charge sheet is filed, my lord, this for filing charge sheet, my lord, 2 years this has been accepted.
Again.
22, my lord, 22 has been amended,
Where
my
is-
lord.
Whether they have said regarding the filing of the charge sheet or they have said regarding the review. Whether
But-
the judgment in the Odeshadri Honorable Apex Court have said that once you file this charge sheet, there is a no question of reviewing the suspension. Is it correct?
My lord, review.
the law?
My lord, reviewing there's, when a charge sheet is filed, my lord, it is not
What is
90
the law?
days.
That means you need not review once you file the
My lord,
charge sheet.
it is not a case, my lord. The 90 days.
You go to the
stipulate-
law.
My lord.
90 days, that's why they said you are required to, if you do not review.
My lord. Especially when my lord, charge is not filed. My lord. That is Ajay Chaudhary also says.
So
my
that
lord,
means the other way, that
My
means once you file the charge sheet, then means no review
but
is required.
subsequently, my lord, it will be, my lord, subsequently,
What is the requirement of review then in suspension? What is the requirement?
my lord, charge sheet, if it is going on, my lord.
Why review is required?
Review, my lord.
Why? Tell us why the review is required.
My lord,
See, a person is getting salary 50% from the public exchequer.
my lord, that's.
After sometimes he's getting 75% salary of his exchequer. He is getting everything.
My lord.
He is getting quarter, he is getting everything on the public exchequer. People are paying from their own pocket
My lord,
to
my
pay a particular incumbent who is under suspension for 8 years, 9 years.
My lord, that is why my only
Then
humble
why
submission.
tell Mr. Tagum why the review is required?
My lord, that is my humble
So
submission.
the
Once charge sheet is
government-
filed, we need to get the status, my lord. That's
See,
present status, my lord.
Mr. Tagum, the government officials can allow another government official to remain in under suspension for a longer period at the public expenses
My lord.
without rendering any service, getting a salary up to 75%. Right? That is the motto. Or
My
what?
lord, my lord, my lord, that is right, my lord. My lord, and that is my humble
Don't
submission. my
argue in
lord.
that
That's
manner. Don't argue. You want time, say frankly, then we'll fix it on in reopening day.
My lord, reopening, because the status latest position is to receive, my lord. That has not been
15,
received.
we
That
have
is why.
the interview at 4:30.
May I be permitted to mention item 11, my lord? Lordship, please, may I be permitted to mention item 11, my lord? It's the next matter, my lord. It's for the appointment of a respondent's nominee arbitrator. They are open to the appointment of Justice Vineet Saran, my lords. We had appointed Justice A.K. Sikri, and they had proposed the name of Justice Vineet Saran in their reply. Lordship may kindly consider and appoint on their behalf. my lords.
So you don't have any objection if, as been proposed by the respondents, the name of His Lordship Vineet Saran is appointed as an arbitrator?
Yes, my lord. Justice Vineet Saran is also a retired honorable judge of the Supreme Court.
As the arbitrator?
Yes, my lord. On behalf of the respondent, my lords.
May I please, Your Lordship, in this matter, Your Lordship? Mr. And rather, he is the conducting counsel, Your Lordship. He is not available now, Your Lordship, because he had, due to some urgent work, very emergency work, Your Lordship, he had to leave the court premises, Your Lordship.
Can we fix it on 15th? Link is off, I think. List on 15th.
May I
No
please
touch.
ask? My lord, item number 23, my lord. My lord, there is interim order that may be extended, my lord. Item number 23, my lord.
Which are the items that are interim? Can you tell us?
Okay.
You send us, we'll pass the order.
My lord, item number 43, can it be taken up tomorrow in the admission? Item number 43.
What's the matter about?
It's regarding framing of RR rules. Even yesterday I have mentioned it. Can it be listed in the first?
Okay, list tomorrow.
I'm
First-
sorry.
Lordship, may I mention item number 26 and
Lordship,
27?
consider-
Can I?
Yes, that suddenly we have, there's a connection snap. We are fixing it on 15th.
Very well. Very well.
15th.
Can it be fixed on 6th of August, 26 and 27 item number?